Good morning. Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, Hall, Hinojosa, Middleton, Parker, Perry, Schwertner, Zaffarini, Paxton, Hughes.
Here. Welcome, everyone. As is the case around here, especially this time of session, many members of the committee are on multiple committees, and those that are not on multiple committees meeting now have bills in other committees that are meeting now. So folks will be in and out. Everything's being taken down, of course, and members of the staff are here, and also the broadcast are being observed. So this is how the process moves through. Thankful for everyone's participation. Glad to have Senator Cook with us this morning. Senator Cook and Senator Parker have bills on related topics, so it is our intent to allow the authors to lay out each bill and do invited testimony. And so the topic I'm referring to is e-cigarettes broadly. And so there'd be Senate Bill 1313, 1314, 1316, and 1698. So if you're here to testify on those bills, if you're invited testimony, you'll be called up as the bills are laid out. Then after all those bills are before us, again, we'll open up the floor for public testimony and let us know which bill or bills you're testifying on. And we'll just move through the agenda. There's one bill today that we expect to have a lot of witnesses on, invited and public, and that is Senate Bill 30, Senator Schwertner's bill. And so that bill will be heard at the end of our agenda. We're going to move through as quickly as we can. We hope to begin that bill before the Senate comes in this afternoon, but we may or may not, but we'll get to it as quickly as we can. But it'll be our plan now, subject to change. Our plan now is to have SB 30, the last one on today's agenda. Sometimes these things change based on availability of members and witnesses, et cetera. So with that, the chair now lays out Senate Bill 1313 and recognizes its author, our colleague Senator Cook, to explain the measure. Good morning.
Good morning. Happy Monday, Chairman and member. Honored to be here with y'all bright and early. Thank you for the opportunity to lay out SB 1313. During the interim, a group of concerned parents reached out to my office when they heard that a smoke shop was opening 2 doors from their children's elementary school. Every day, when the parents drop their children off at school or walk them to the school's entrance, they must pass by a smoke shop retailing harmful tobacco and e-cigarette products. Naturally, the children became curious about these products being sold in a smoke shop, especially when these smoke shops use lucrative advertising techniques targeting students, considering the e-cigarettes remain the most commonly used tobacco product among minors. Upon further investigation, our office recognized a trend across Texas, especially in cities like Houston, where smoke shops open and operate near schools. Smoke shops use fictional characters and cartoon-like images in their store logos and advertisements to lure students into their stores. We actually heard from a couple of parents that their kiddos were saying, "That looks so fun, can we go in there after school?" No, please. SB 1313 aims to address these concerning marketing trends by prohibiting smoke shops from employing deceptive marketing techniques to entice minors to purchase and consume harmful tobacco and e-cigarette products. SB 1313 prohibits retailers from using visuals appealing to minors in their shop logos, signage, or other design mark. Any violation of this section is a Class B misdemeanor, and in some, it ensures the physical and mental well-being of our future generation. We do have a committee substitute for this one as well that is ready, and it just incorporates language recommendations from the Comptroller's Office to clear up ambiguity and make enforcement more realistic. If you have any questions, I'll be happy to answer them, and thank you so much.
Thank you, Senator. And Senator Zaffarini sends up the committee substitute, which the author has explained to us. And Dean, any questions for Senator Cook at this point? Very well. We'll begin with invited testimony. Senator Cook will call up your invited witnesses, and then we'll, if you'll stick around, we're going to lay out the rest of your bills as well.
Perfect. And their testimony may relate to the other 2 bills as well. Okay.
Very good. Thank you. We'll open up testimony on Senate Bill 1313, and the chair calls Mehdi Rice and Lila Rice. Have a seat there next to Senator Cook. Make yourselves comfortable.
Speak right into the microphone.
All right, whoever, when you're ready, whoever wants to go first, tell us your name, introduce yourself, and give us your testimony. Welcome. We're glad you're here.
Hello, my name is Lila Rais, and I am here to speak in support of Senate Bills 1313, 1314, and 1316 with my dad. Smoke shops should not be so close to my school. The cartoons and bright signs on this shop look fun, and it is confusing because what they're selling isn't for kids, even though it looks like it is. My dad and other parents have worked hard with Senator Cook to write these bills, and I am grateful you are hearing them. Thank you for your consideration.
And thank you for your testimony. It's good to have you here. Thank you. Welcome. Introduce yourself. Go ahead.
Great work. Thanks so much for having us. Hello, my name is Mehdi Reyes, and I'm speaking in support of Senate Bills 1313, 1314, and 1316. Every morning, my daughters and I walk to school, and before school, we visit the school's playground. Last year, a smoke and vape shop called Bahama Mama opened 30 feet away from the kids' playground. In fact, the smoking deck of the smoke shop is just across the fence from the playground, and smoke wafts over into the playground, where kids as young as 4 years old play. The advertisements and signage of this shop does not look geared towards adults, but intentionally children and young people. It feels like deliberate stimulation to draw children in. My youngest started to ask if we could go in there because it looked fun. She's right behind me. I find myself in the position of having to explain to my daughters what the shop is, what the products are, and how they'll impact their growing bodies. I'm happy to have difficult conversations with these kids, but it shouldn't be because the smoke shop is 30 feet away from the school and their playground. It should be on our own terms. After experiencing this, I began to research with other parents. I looked up data on the comptroller's website and compared it to HISD maps. I saw a troubling pattern. These shops are often located around schools. Any reasonable person should understand we're just trying to manage what is age appropriate for our kids. These bills each close loopholes we ran into when we tried to curb the shop's advertising to our children. I really genuinely appreciate the committee's consideration. I'm hopeful we can pass these bills and pass a reasonable solution for parents and children across the state. Thank you so much.
Mr. Rice, thanks for your testimony. Senators, any questions for Lila or for Mehdi? The Dean of the Senate, you're recognized.
Mr. Reyes, do you think there should be any repercussions for the children who buy these products?
I haven't really thought about that. Repercussion for children. I haven't really even begun to think about that. I think about the barriers of attracting kids and getting kids into these stores, and I think it starts there. But as far as the kids going in, 4-year-olds and 5-year-olds that are located next to a smoke shop, if they're given a gateway into those smoke shops, I think there should be some kind of barrier from keeping them from getting attracted into them and then getting into those smoke shops. But as far as punishment, I haven't really thought about it.
Well, I'll tell you why I asked that, Mr. Chairman. When we dealt with the issue of tobacco products sold to minors, we had penalties for the retailers. And there were some members of the Senate who would not support the bill because there were no penalties or there was no repercussions for the children. And they said it's the children, the minors, who are doing this, and so we should have repercussions for them. It was my bill, and I bitterly opposed it, so I wouldn't bring up the bill because I didn't want the minors to be held responsible in any way. I thought it was the retailers who were doing this deliberately, and the manufacturers, the tobacco industry, who were deliberately doing all these things. And then I did what I always do. I asked the people who are impacted by the bill, and I asked a minor, why is it that your friends have said, of the children your age who smoke, how many of the 10 people you know best, how many smoke? And he said, 7. And he said, I don't, and 2 others don't. And I said, why don't you smoke? He said, because we're athletes. He said, so we don't smoke or drink. And I said, then why do these not teenagers, but why do these minors who know that it's illegal to buy tobacco products buy them anyway? And he said to me, and I will never forget, Mr. Chairman, it was in this building, in my office, he said to me, because if you get caught, nobody does anything about it, and we all know it, and that's why no one respects the government. I came back and changed my bill.
If I may offer, one of the bills that is in this package that has not yet received a hearing is one to prohibit minors from going into these shops, period. So it brings everything up to alcohol par. And then you actually do have to break an existing law in order to still get your hands on it. In my opinion, like from a public health perspective, the further upstream you go, the more effective your intervention is.
Right.
You're kind of closer to the fulcrum. So if we were able to pass all of these and then a student still had to use a fake ID to go and purchase, then you're kind of capturing it on both sides.
Well, I went back and changed my bill and got the support, and the governor changed, it was Ann Richards, she changed her position, the lieutenant governor, Bob Bullock, we all changed our position based on that one minor and what he said. Yeah, we talked to additional ones after that, but that's what he said. Nobody does anything to us, who cares? And so the penalty was, of course, community service. So it was just lesson learned, something constructive,
That makes sense.
not jail time.
Thank you, Dean. Senator Paxton, you're recognized.
Thank you, Mr. Chairman. I had a question for Senator Zaffarini. The acoustics in here are terrible. What was the reason that the minor gave you for why they and the two friends did
He
not?
said that 3 of the 10 did not smoke or drink. And I said, and why don't those 3 smoke or drink? And he said, because we're athletes.
Because we're athletes. Okay, the word just kind of reverberated. It was hard to understand, because we're athletes. Well, and we all know that, a lot of this starts at home, right? That's good peer pressure and good adult influences teaching those kids that,
Yes.
you need to take care of your body. It's your body. You're going to live with it for the rest of your life. And some of us are realizing what that looks like, right? Yes. When we get into our 60s and up. And anyway, well, thank you. I appreciate you sharing that. I think that's important. And I agree also with, I think age gating on a lot of these issues is very important and does take care of some of those things. But thank you, Senator Cook, and I'm proud to be on these bills with you. I think they're great. Thank you, Senator. Thank you, Dean, and thank you, Chairman.
Thank you, Senator. Members, any other questions for Lila or for Mr. Rice? Thank you for being here. Glad you came. Thanks, Lila. Great testimony. Great job. So it is the chair's intent to leave 1313 before us and to lay out the next bill, and we'll get all the related bills together, and then we'll hear our public testimony. So the chair now lays out Senate Bill 1314 and recognizes its author, Senator Cook, to explain the measure.
Thank you, Mr. Chairman and members. And I loved that discussion, Dean. I'm excited. I think if we were add penalties for minors, the first thing to do would be to get them away from schools where kids are going to stumble into these places. So SB 1314 expands the current definition of an e-cigarette in section 161.0876 of the Health and Safety Code, which prohibits the advertising or sale of e-cigarette products containing nicotine if their packaging includes symbols or images targeted towards minors. So e-cigarette use among minors continues to rise, including the use of nicotine-free vapes, and these products may still contain harmful substances such as formaldehyde and other toxic chemicals that pose significant health risks. During the 88th session, the Texas legislature enacted legislation prohibiting the marketing of e-cigarette products to minors using imagery like cartoon characters, celebrities, or colorful trademarks. But this builds on this progress by extending those same advertising and marketing restrictions to e-cigarette products that do not contain nicotine. We know that there's all sorts of vapes, there's all sorts of carrier oils and heavy metals in there. This ensures that nicotine-free vapes with dangerous chemicals are treated the same as those containing nicotine, helping protect our kids from harmful exposure. Again, if you have any questions, I'm happy to answer.
Thank you, Senator. Committee members, any questions for the author on Senate Bill 1314? Very well. So in a moment, we're going to hear public testimony on all the e-cigarette bills. And so Senate Bill 1314 is still before us. The chair now lays out Senate Bill 1316 and recognizes its author, Senator Cook.
Thank you, Mr. Chairman and members. Thank you for the opportunity to lay out SB 1316, which closes an existing gap relating to the marketing of tobacco and e-cigarette products. Currently, Texas law prohibits the advertisement of cigarettes and tobacco products within 1,000 feet of a church or school or any faith home. However, this prohibition does not apply to e-cigarettes. 1316 applies the same advertising restrictions that prohibit the advertising within 1,000 feet of a church or school. If you have any questions, I'm happy to answer them. And then just to kind of recap, so 1313 is about the outside of the building, essentially. 1314 is helping us capture all of these vaping products, not just depending on whether or not they contain nicotine. And 1316 is about where you can actually advertise them.
Thank you, Senator. Members, any questions for the author on Senate Bill 1316? Very well. Those three bills are before us, and now we'll recognize Senator Parker to lay out Senate Bill 1698.
Thank you, Mr. Chairman and members. I'm pleased to offer Senate Bill 1698 for your consideration today, a bill that addresses an urgent gap in Texas law and gives our state the needed tools to enforce against illegal vape products that are pouring into the Texas market from China. Senate Bill 1698 addresses a true lack of clarity that undermines enforcement and leaves us open to legal loopholes. It sets the legal foundation for Texas to create a vape product directory, a proven tool that lets the state say, if it's not on the list, it's not legal to sell here. This isn't a new idea. We already use directories for other regulated products like cigarettes, tobacco, fuel, and other pesticides. If you even want to sell those products in Texas, you must meet federal or state requirements and be registered. Senate Bill 1698 gives Texas the same enforcement power for vapes, and we need it urgently. Right now, the vape market in Texas is being flooded with illegal, foreign-made products, mostly from China. These are mass-produced in unregulated factories and shipped straight into U.S. retailers, often in direct violation of federal law. In fact, China has banned these products, but are willingly fueling the illicit vape market in Texas and across our nation. These aren't just ordinary products. They're engineered to attract children. Some of the newest devices are designed like video game controllers with animated screens, flashing lights, and gameplay built right into the vape itself. This isn't accidental, it's intentional. This is foreign manufacturers designing addictive nicotine products and marketing them like toys to America's kids. Mr. Chairman, I'd like to pass out a couple of examples of what these look like to the members. Senator Middleton, you would pass them around. I encourage you to open them up, take a look, and you can see this video game component, all the different flavors and smells that are all targeting children. And so that's why I want to share with you those products so you understand exactly what's going on here today. They know exactly what they're doing, Mr. Chairman, and what we're letting them, effectively we're letting them do it today because we don't have the legal framework to stop them. The FDA, to be quite simply put, is overwhelmed. They've publicly said they can't keep up. Thousands of vape products are being sold without federal authorization, but federal inaction doesn't mean that Texas has to sit on its hands. Just like we do with other regulated products, we can require that vapes meet federal requirements to be sold here. That's what a product directory does. If it's not authorized by the FDA, it's off the shelf in Texas. That's not radical, that's simply responsible enforcement. And Texans are behind it. A recent poll shows 88% of Texas voters support stronger enforcement to keep illegal vapes out of stores. This is not controversial, it is common sense. Let me be very clear. Senate Bill 1698 does not ban any products that are not already illegal to sell. It does not ban vaping. What it does is restore control to the state of Texas. It lets us say, if you want to do business in our state, follow the law. Let me say that one more time. It does not ban a product that is not already illegal. So for anyone about to testify against this bill, be prepared to answer the question, are you currently selling products which are not FDA compliant? Because right now, China is dictating the rules of the vape market here in Texas. Senate Bill 1698 pushes back. It gives law enforcement, prosecutors, and state regulators a clear, enforceable path to clean up the market and protect our communities and our children. Texas shouldn't have to rely on Washington, D.C. to defend our health and sovereignty. We've never waited on the federal government to lead, and we don't have to now. Thank you, Mr. Chairman and members, for the opportunity to lay out the bill, and be happy to answer any questions. I will just comment that I'm aware of the potential fiscal and FTE implications to the Comptroller's Office if this bill is implemented as filed. My staff is working on language which will alleviate the concern by allowing the Comptroller's Office to enforce the statute the same way they enforce the existing statutes with relation to all other tobacco products, and I'll bring that back to you in the form of a committee substitute very soon. So again, Mr. Chairman, happy to answer any questions and appreciate the opportunity to lay out the bill here this morning for you and the members.
Thank you, Senator Parker. Members, any questions for Senator Parker on 1698? Senator Paxton, you're recognized.
Thank you, Mr. Chairman. Senator Parker, thank you for this bill. And I don't know if you were able to hear any of the previous invited testimony.
I caught the tail end, Senator, but please go ahead.
Did you hear the father say that he had grown weary of having to explain to his kids why they couldn't go in there, and that one of his daughters had actually said, "Can we go in there? It looks fun."
I did not, unfortunately, see that, or hear that, rather, but it doesn't surprise me, Senator, because in doing our research and talking to folks across Texas, you know, they are directing all their marketing efforts at young children, not kids that are at 20 or 21. If they're 21 or above, they can do what they want to do. But when you got kids in elementary school that are being targeted, it's just horrific. And, you know, you can open up that box, you can see it, and you'll see that it's, you know, has a video game-like component. I mean, it's crazy.
Well, and
I mean, it's a game.
And I'll do that, but I would just like to thank you for making the same point. It looks fun,
Yes.
right? And I haven't opened this yet, but I will. I can't open packaging very well. I'm always afraid I'll break a nail.
Hey, I understand.
Well, you know, it's even more tempting when it's hard to get into. So, but you know, you can see the colorfulness of
Oh,
this.
absolutely. And you'll turn it on, when you'll turn it on, and then you'll see the screen, looks like a little video screen. I mean,
Wow,
And then
really?
you'll see the smells. I mean, you know, you'll smell strawberries and bubble gum and, you know, all kinds
Yeah.
of stuff. I mean,
Well,
it's,
Pineapple punch.
there you go.
That's,
There you
I
go.
know
That
that's
one's
what
pineapple punch.
Senator
I know we
Dean
got some
Zaffarini goes
strawberry
for all the
and
time.
bubble gum.
She's always after the pineapple.
You got Cherry, Dean Zaffarini? Yeah,
Mm-hmm.
yeah. So, look, that's the issue. I know it's tough to be in business. We recognize that this directory takes away the challenges for a retailer. They'll be very clearly go to a directory and understand what's appropriate and what's not for their shelves. But we've got to protect our children. We've got to take this seriously.
Well, I would like to applaud the fantastic marketing that this is. This is a great example of marketing. The problem is, it is marketing to children.
Yeah.
And I don't applaud that. That's the wrong way to go. So thank you, Senator Parker.
And illegal in China. A lot of the packaging will say that as well.
Wow.
But it's okay to flood our market here with it. So just to be very clear.
Thank you.
Thanks, Senator Paxton. The Dean of the Senate is recognized.
Thank you, Mr. Chairman. Senator Parker, did you at all track or would you consider tracking the restrictions for exposing minors to tobacco products?
Yes, I mean, I think that's important. Again, we should be protecting our minor children. That's the focus of.
But I think if we track that, the restrictions that we have now for minors' exposure to tobacco products, we might get some more ideas. For example, for tobacco products, we prohibited the distribution of kiddie packs. And that's what the tobacco industry was doing at the time, distributing kiddie packs of free cigarettes at football games. So
Absolutely.
They not only had the billboards, but they had all these little giveaways.
Senator, I agree with you completely. We should be tracking that information, that data as well. It's very important.
So maybe track that and see if we could amend that into the bill if you're interested.
Happy to continue the discussion with you.
Thank
yes,
you.
ma'am.
Thank you, Dean. Any other questions for the author? Very well. At this point, Senate Bill 1698, Senate Bill 1313, Senate Bill 1314, and Senate Bill 1316 are all before the committee, and we will open public testimony on those bills. So we're going to call witnesses we're going to work through the witnesses that are testifying on multiple bills. And so once you come up to testify, let us know what bill or bills you're testifying on, for or against, and we'll go from there. So the chair calls Dr. Shiva Gabala, Paul Harden, Charlie Gagan, Honorable Mark White, Charlotte Owen. Oh, there you go. Over there. There you go. Welcome again. For each witness, we'll ask you to tell us what bill or bills you're here on. Introduce yourself. Give us your testimony, Councilman. We'll start with you over here. Welcome. Introduce yourself and tell us what bill or bills you're on, and go ahead.
Well, thank you very much for having me, Mr. Chairman.
And get close to that mic when you're on the end, especially.
You got me now? All right, well, thank you for having me, Mr. Chairman. My name is Mark White. I'm a city councilman in San Antonio representing District 10, here today testifying on SB 1698. But I want to tell you, I applaud the efforts with respect to all of these e-cigarette bills. 36% of, and I should say I am here testifying in my individual capacity, as the city of San Antonio hasn't taken an official position yet on 1698. 36% of vape shops in San Antonio are within 1,000 feet of schools. These vaping devices are being found not only on middle school and high school campuses, but even on elementary campuses. In 2024, Northeast ISD had over 750 instances of kids having these devices on campus, more than half with THC. Northside ISD had 1,367 such instances, with about a third of them instances containing nicotine and CBD. We have got to protect our children. Our children are very, very vulnerable to these types of devices. Senate Bill 1698 attacks part of the problem. Our kids are so vulnerable to these illegal manufacturers of these products, many of which, as have been stated earlier, are sending them in from China. I think I saw numbers that China takes in annually somewhere close to $5 billion from selling these illicit vaping devices here in our country. There's reports that they're even looking to work with some of the Mexican cartels to further gain control over this really black market to sell these things to kids here in our country, in our state. And for me, this is a real problem in San Antonio. So I want to applaud the efforts of this committee to take up these bills. This is a public safety issue of the highest priority for our state and for me in San Antonio, and that's why I'm here today to testify in support. Thanks so much.
Yeah, thanks for your testimony. Sergeant, welcome up. Introduce yourself, tell us the bills you're here on, for, or against, and give us your testimony.
Thank you, Mr. Chairman and committee members. My name is Paul Harden, President and CEO of the Texas Food and Fuel Association. Our organization represents convenience stores and fuel distributors throughout the state, and I am here in support of Senate Bill 1698 by Senator Parker. Basically, we just need, in Texas, retailers need to know give us a reliable source, a list of what products, vape products, are legal to sell and what are not specifically. Many of our members report difficulty in just trying to figure out what vapor products are regulated, which are not. It's almost like the wild, wild west out there right now. And since 2020, the vapor market's been just absolutely flooded, as you all know. with flavored disposable products that are illegally imported in the United States, much of it coming from China, that you've both spoken of. And unfortunately, there's no comprehensive source right now that lists these legal vapor products, and it puts our members and frankly the consumers at risk. It was, I think Senator Parker mentioned that a little note, illegal Chinese-made flavored disposable vapor products have flooded the U.S. market, and the Chinese government has outlawed these products. They don't want to sell them in their country, but they'll ship them over here to our kids and others. So we are fully in support. We need Texas's support with creating a central system for wholesalers and retailers to understand which products are to be sold so that we can do exactly that and stay out of the gray area. Happy to answer any questions.
Thanks for your testimony. Senator Parker, go ahead.
Thank you, Mr. Chairman. I just want to thank you and your association for being so responsible, doing the right thing with regard to this. And, you know, look, I think you commented so well that people need direction. They need guidance on what is approved and what's not, what's regulated, what's not. And that's what we're really trying to do here with this list. So thank you very much for being here.
And thank you for bringing this forward.
Thank you. What was, the Dean of the Senate is recognized.
Thank you. Mr. Hardin, I noticed that this product that Senator Parker distributed does have ingredients. These are required to have the ingredients listed, right? All of these kinds of products?
Are they required?
Yes.
Is that what you're asking? I honestly don't even know what the product listing, again, it's such a gray area. I don't, you know, with some of the bills floating out here, it might require listing the products.
Do you know if tobacco products have their ingredients listed?
Yes, ma'am.
They do, or you do know?
They do.
Are you sure?
Let me check.
Check.
Let's see. Contains nicotine.
But do they list the products?
No, ma'am. Actually, it does not.
They do not.
Do not.
We are prohibited to require the listing of ingredients in tobacco products by the federal government.
Perhaps we should write them a letter.
My point is that perhaps we should make sure that these, since these have not yet been protected by anyone, perhaps we should require the listing of ingredients before someone decides to prohibit the listing. Thank you, Mr. Chairman.
Thank you, Dean. Welcome. Introduce yourself. Tell us the bills you're here on and your position, and go ahead.
Good morning, committee. My name is Charlie Gagan. I'm here on behalf of the American Lung Association. We are here in support of Senate Bills 1313, 1314, and 1316. Unfortunately, we are opposed to Senate Bill 1698. For decades, tobacco companies have targeted children with their deadly products. Tobacco companies have been found guilty of racketeering, of lying to the public, and as a result of the Master Settlement Agreement, they have paid Texas more than $15 billion in restitutions, none of which currently goes towards tobacco prevention and quit smoking programs. Unfortunately, tobacco companies, both foreign and domestic, continue to target children today with e-cigarettes and other products. Just 2 years ago, Attorney General Paxton settled a $43 million lawsuit with Juul, an American company, for violating the law and, quote, for its attempts to entice our young people with deceptive advertising. Unfortunately, it's too late. In the last few years, the decline in the adult tobacco use has stalled, driven by the Juul generation as they become adults. Senate Bill 1698 is a tobacco industry bill. It is designed to distract this body from proven policies to reduce tobacco use, and we believe it will have little to no impact. The tobacco industry has been successful in advancing this legislation in 11 other states, yielding little to no result and requiring additional legislation and funding. We believe that the best way to achieve the intent of the author is to prohibit the sale of flavored tobacco products. A prohibition on flavored tobacco products would include all the products that are aimed at children, and we believe would be easier to administer. You just look to see if there's any flavor on the packaging. No need to consult any lists that may change over time. Prohibiting the sale of flavored tobacco products, along with 4 other policies, are outlined in the American Lung Association's State of Tobacco Control report. Texas currently receives failing grades on all 5 of those policies. I will note the FDA does have a very easily searchable and accessible database of the 34 products that have received authorization. We strongly encourage this body to look at proven, effective policies to reduce tobacco use and reject Senate Bill 1698 in its current form.
And we'll have questions at the end of the panel for everybody, so thanks for your testimony. Welcome, introduce yourself, tell us what bills you're here on, and go ahead.
Hi, committee. Can you hear me? Hi, Chair Hughes, Vice Chair Paxton, committee members. I'm Dr. Sheila Gavala. I'm a pediatrician in Houston. I'm representing the Texas Medical Association, the Texas Pediatric Society, and the Texas Public Health Coalition. We are here in support of Senate Bill 1313, 1314, and 1316, all measures that we think will reduce e-cigarette use in youth. However, I'll spend the majority of my time discussing Senate Bill 1698, which we respectfully oppose. Tobacco use, including e-cigarette use, is one of the leading causes of preventable illness and death in Texas. 2 million youth, based on 2024 data, are addicted to these products. The staggering health costs, exceeding $10 billion annually, represent a significant drain on our state's resources. And these funds could be better allocated to vital services like public education and strengthening our public health infrastructure. Senate Bill 1698 undermines our commitment to reducing youth e-cigarette and tobacco use. With the current wording, it would allow nicotine products lacking the required FDA authorization to be included in this registry if the product's FDA application is pending or in appeal. Including these products in a state-sanctioned directory legitimizes unapproved electronic nicotine delivery systems. Instead of investing in a costly and duplicative directory that includes unauthorized, untested, and unsafe products, we urge the committee to use the FDA's registry of authorized products. We also need to focus on robust funding for prevention and cessation programs, increasing taxes on tobacco products, comprehensive smoke-free air laws, and prohibiting flavored products that target young people. Furthermore, effective youth prevention requires a multifaceted approach. Strict 21 years of age and older restriction, enforcement, e-cigarette regulatory parity with tobacco products, and expanded research on the impacts of tobacco and e-cigarette use. This bill does not address the core problem, that these products are addictive and dangerous. We need to focus on evidence-based interventions. Thank you for the opportunity to comment.
And thank you for your testimony. Ms. Owen, make sure and get close to that microphone and introduce yourself and tell us the bills you're here on, and go ahead.
Hi there. I will first address 1698.
Even though I said it, go ahead and give us your name.
Charlotte Owen. I'm the Vice President of the AVM, American Vapor Manufacturers Association. I'm also an FDA regulatory consultant, so I do FDA work every day. So if you have FDA PMTA questions, I'm your person. Most of the products that come up have SDN numbers. And SDN number is the way the FDA said, I've looked at the ingredients, I've looked at the science, I've looked at the toxicology. These are acceptable to, to be in the queue. In other words, I don't recommend any products to be on the shelf that don't have an SDN number by the FDA. Even Customs refuses shipments that don't have an SDN number. However, the PMTA process is about a 10-year process. So a lot of good products are on the shelf. I've included in my testimony, which I'll give out, an HPHC, diagram to where it shows what are cigarettes, HPHCs, which are hazardous chemicals. Sorry, I do that, toxicology by nature. Hazardous chemicals. To your question, it also lists the ingredients, the environmental assessments, those things. Those are things that we need in Texas. Altria actually bought their way into the American Legislative Exchange Council, and to quote them directly, prohibitous policies, including bans on flavored tobacco meant to protect children and teens, create so much unintended consequences, illicit markets, and burdens on law enforcement. It's a burden on the criminal justice system, said Martin King, Altria's senator director. If that's how they feel, why are they pushing a ban in Texas? In other words, they do that because it's better for their bottom dollar. I like responsible harm reduction. We don't want this in the hands of kids at all. So, including every state that has done anything like this has seen a 20% increase in the black market. However, we can do better. We can have a Texas list that is tied to an STN number. That means they've done the science. So I do advocate, I'm on this bill because I've been working with Brennan to talk about how we can change this to be a Texas first. And that's really my goal, Texas first. So that's SB 1698. Do you want to do questions? Yeah.
No, go ahead.
Okay.
Give us a position on all the bills, and we'll see about the questions at the end. Thanks.
SB 1313. We are in support of SB 1313 with the AVM. But, however, there's some reasons why I love the bill. One, it doesn't say what type of retail establishment. So you don't have an exclusion for any type of tobacco establishment. You have all establishments. I love that. However, we do feel that there's a packaging bill that we helped push with Tony Tenderholt last session, that we feel like this has a lot of that in it, but Senator Perry's bill, SB 2024, goes a little further. We have watches, we have cell phones in that. So we feel like SB 1313 should include a lot of SB 2024 as well. So SB 1314. This is changing the definition of the e-cigarettes. We are not for this bill because we've seen this have pretty awful consequences in other states. It could be changed to where it's specifically for zero nicotine e-cigarettes, but it basically just expands it to anything vapable. So we think it can work, but it needs to be amended to include zero nicotine phrase instead of just anything that can use the technology. There's a whole lot of things like vitamin vapes, things like that bodybuilders use that actually have good science behind them. So this would affect them as well. So we just think it needs to be narrowed down a bit. SB 1316, we are in support of this bill. However, we would like to see the 1997 criteria removed. This allows other establishments, tobacco establishments, to advertise cigarettes to kids. E-cigarettes were not on the market in 1997, but cigarettes were. So, and I may not know the law, so there may be something that prohibits them from targeting kids with cigarettes, but when I was a kid, I went across the street and got mine at the White Oak Roughneck, so in White Oak, Texas. So I don't want to see a Marlboro advertisement on the convenience store next door. So that's the only reason why I love the bill. I think advertising restrictions are wonderful, but I think we need to remove that 1997 criteria. So.
And thanks for your testimony. Senators, if you have questions for any of our witnesses,
Thank you.
let me ask a couple of questions, and I thank each one for being here. So, Mr. Gagan, I don't want to mischaracterize your testimony, and I thank each witness for being here. It takes courage to come up here whether you're on, for, or against, and so we want to make sure we get all the information out. Now, I don't want to mischaracterize your testimony, but on 1698, it sounded like your concern was that there was a better approach, but yes, sir. Is it also that you're against what's in 1698, or you just think we should do more or do it differently? I'm not fussing at you. I want to understand.
Absolutely, I appreciate the question. Our concerns with 1698 are, first and foremost, we don't think it will work. We've seen 11 other states try this, and it has had little to no impact. Second, we think that it is duplicative. The FDA list is easily accessible, easy to navigate. It's got 34 products on it. Why does Texas need to create its own separate list that will constantly be changing? And then lastly, again, we think a more effective way to do this would be flavors that would be much easier to enforce and implement as opposed to referencing a directory.
And thanks. I just want to understand that because would it be possible for us to do what's in 1698 and also do what you're suggesting, or would they be in conflict?
I'd be happy to look at that language. I think one of the big concerns we have with 1698 is that it allows both products that have received authorization and products that have merely applied to receive authorization. So in other states that have done the same thing, they have up to 12,000 products listed on their directories, seemingly implying that they are legally sold in the state when they are unlawful to sell based on the FDA guidance.
Yeah, thank you. Members, any other questions for any of these witnesses? Thank you each for being here. You're excused. Oh, yes, give your written testimony to the lady right over there. Thank you. We'll continue public testimony on all 4 of these bills, and the chair calls Todd Wages, Holly Veal, Scott Rand, Terry Lee, J.R. Gonzalez. Again, looking for Todd Wages, Holly Veal, Scott Rand, Terry Lee, J.R. Gonzalez. And the chair calls Terry Lee and Stephen Callahan. So we're going through all the witnesses who have registered to testify on, for, or against any of these bills. I want to give everyone a chance. So we're looking for Todd Wages, Stephen Callahan, Holly Veal, Scott Rand, Terry Lee, J.R. Gonzalez. And if I called your name, come on down and have a seat here at the table. Yes, sir. If I called your name, have a seat at the table. If not, we'll go ahead. So we're looking for Todd Wages, Stephen Callahan, Holly Veal, Scott Rand, Terry Lee, J.R. Gonzalez. And if there's not seats for everybody, we'll get you on the next one. So hold tight. We'll get you on the next panel if we're out of chairs. Oh, that's okay. Hold tight. We'll call you on the next one. Sorry about that. We want to get everybody we could. Thank you very much. We'll start over here on my left, your right. And so on the end of the table, get close to the microphone. Yes, sir. Introduce yourself.
Okay.
And go ahead.
Good morning, Chairman Hughes and members of the Senate State Affairs Committee. My name is Scott Rand, and I'm here on behalf of Rand Oil Company from Beaumont in support of the Senate Bill 1698, a vapor product directory for Texas. I operate 5 retail stores in the Beaumont area. My family's been in business for 58 years there, and we employ approximately 40 people. And we're proud supporters of our local communities. Vapor is the 2nd largest tobacco category in the United States, but it's in a state of disarray because it's been flooded by Chinese national tobacco monopoly, illegal vape. And that puts a tremendous burden on small business or even larger store chains that want to abide by the law and are invested in their community's well-being, as we are. This bill would be a big step towards getting legal product only on the streets, safe product, and give retailers, myself, a good understanding of what is and what isn't legal. Otherwise, we're just kind of, flying by the seat of our pants. I don't think that the vapor, this list will in any way curtail the consumer's choice for these products. There's over 350 that would be on the list, as I understand it now, so they'd have plenty of variety. They wouldn't have access to the illegal Chinese product. And my concern there also is being imported illegally. They they're not subject to any kind of oversight as to what's actually in them. And with this fentanyl crisis that we have possibly, it's a really easy introductory device. And I'll just add at the end, they're targeting the children because the reason that my stores and others, the legal ones, are not all the bubble gum and watermelon, and they even have some now with video games on them. Right. They're appealing to children.
Right.
And that's what this will really help avoid.
Thank you for your testimony. Thank you for being here. Welcome. Introduce yourself and go ahead.
My name is Todd Wages. I'm opposed SB 1698. Good morning. Thank you, Mr. Chairman and members of the committee. My name is Todd Wages. I'm the CEO of Wages and White Lion Investments. I'm an e-liquid manufacturer and distribution company based in Dallas, Texas. My company is also a member of the Vapor Technology Association. Thank you for the opportunity to speak about vaping products. I and the VTA share the sponsor's goals of having a safe, regulated industry which ensures products are properly labeled and marketed to adults. We appreciate Senator Parker's efforts to tackle a complex issue, but we believe this bill as it is drafted is a misguided approach. SB 1698 creates a vape product directory that will eliminate virtually all flavored vape products sold by thousands of Texas retailers. FDA has only authorized about 10 unique vaping products. We've heard 34. Those are actually the charging devices and things like that. There's actually 10 if you looked at it just as the product. All of which happen to be owned by out-of-state big tobacco companies. Texas is my home. I built my business from nothing, and we now employ over 45 Texans. We are a leading distributor and manufacturer of vaping products, not just here, but in around the country. I am also the plaintiff in a lawsuit against the Food and Drug Administration that is now pending before the U.S. Supreme Court. The Food and Drug Administration denied my applications for bottled e-liquid back in 2021. Last year, Judge Andrew Oldham, who you all know well, opened the Fifth Circuit's opinion in my favor as follows, quote, "Over several years, the FDA sent manufacturers of flavored e-cigarettes on a wild goose chase. Judge Oldham concluded, the FDA's denial of petitioners' PMTAs were arbitrary and capricious. The agency did not give manufacturers fair notice of the rules. The agency ignored reasonable and serious reliance interests that manufacturers had in the guidance, and the agency tried to cover up its mistakes with post hoc justifications. We therefore hold the agency acted unlawfully. I'm opposed to this bill, even though my company's products may be spared, merely because I could sue the FDA. Most other competing products will not be spared. My products are sold in age-gated specialty vape shops. But if this bill becomes law, I guarantee that every one of those shops will be closed and there will not be enough products for them to sell. So it will do me no good to have our products listed on this directory if all of my consumers are shut down. If this bill passes, 5,500 jobs in Texas will disappear, as will $311.4 million in wages and benefits paid to those workers. Overall, the economy of Texas will be $1.2 billion.
Conclude that thought. We're trying to respect the time for all the witnesses we have today. Go ahead. Conclude that thought.
I'm opposed to this bill because it has been driven by out-of-state tobacco companies who have come here to shut down my business in Texas and the Texas customers. I'm opposed to this bill. This is the last part. I'm opposed to this bill because I don't want to see.
That'll do it for now. We'll have questions at the end. Thanks for your testimony. Welcome. Introduce yourself and go ahead. And let me pause for a minute. We have a lot of bills, a lot of witnesses today, and so we're trying to stay close to those time limits for the benefit of all the witnesses. So introduce yourself, and also that testimony that stays within the time limit is a lot more memorable than that testimony that goes beyond. I'm just telling you the truth. Go ahead and introduce yourself. Give us your testimony.
Good morning. My name is Holly Veal, and I'm here today on behalf of Core-Mark Wholesale Distribution to urge you to support Senate Bill 1698, an e-vape product directory in Texas. Core-Mark has operated in Texas for 25 years. We're headquartered in the DFW area and operate 2 distribution centers. Core-Mark employs over 1,100 Texans and distributes nearly 10,000 products to more than 3,000 retail locations in our great state. Although vape and e-cigarette products have been shown to be substantially less harmful than traditional combustible cigarettes, consumers continue to face unnecessary risk due to the confusing landscape of approved products. In addition, the complexity and lack of enforcement has created a competitive disadvantage to law-abiding corporate citizens, allowing demand to funnel into non-compliant, illicit products serviced by smaller distributors who lack the resources to validate legality. Core-Mark has experienced this firsthand, just how difficult it is to know which vapor products are regulated and which are not. Since 2020, the vapor market has been flooded by illicit Chinese to vape products with highly flavored disposable products that are smuggled into our country. Unfortunately, there is no source listing vapor products that are legal to sell. The adoption of a product directory in Texas will allow reasonable distributors and responsible distributors and retailers to know what is compliant and what is not. In addition to protecting consumers, a product directory would facilitate an equal playing field for all in the state of Texas and to protect Texas businesses from federal enforcement from unknowingly distributing and selling non-compliant products. The proposal is good for Texas because most distributors in the state want to abide. We just need a mechanism to understand it. The product directory will provide wholesalers with the information we need to ensure that we're distributing compliant products and avoid penalties. The proposed product directory will also help fund equitable enforcement.
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
Good morning, Mr. Chairman, members of the committee. My name is Steve Callahan. I work for Altria, and I lead our brand integrity and enforcement department at the company. I'm here to voice our strong support for SB 1698. At the highest level, what we're talking about today is that there are two markets. There's a market for companies like mine that play by the rules, seek to work within the regulatory system, seek to get authorization from regulators, and provide information about the ingredients that are in our products and how we market those products. There's a second market, mainly made up of Chinese illicit vape manufacturers who smuggle their products into this country, do not disclose their ingredients, and market their products in any way that they desire, including by putting video games in those products. This unregulated market causes several serious concerns. As I referenced, we don't know what is in the product, and we don't know how they're marketed or to whom. This bill is a common sense solution that has been passed in 12 states. It's actually only, if I remember correctly, fully in effect in one state. Other states are coming online. And it shows that you can continue to offer adults choice of products. Louisiana has more than 300 products on its registry, and it drives down illicit vaping markets. I think most importantly, you have companies like mine who seek to play by the rules. We're here to testify in support of this regulation, in support of this legislation. You don't have the Chinese manufacturers here testifying in opposition to it because they know that they're selling illegal products. Thank you.
And thank you for your testimony. Welcome now. Since you're on the end, get close to that microphone and introduce yourself and go ahead.
Good morning, Mr. Chairman and the committee. My name is Terry Lee, and I'm here today on behalf of the Eagle Nest Travel Center located in Brock, Texas, right west of Weatherford. I'm here to support Senate Bill 1698, a vapor product directory in Texas. We operate a travel center located on I-20 west of Fort Worth, and we're a proud supporter of our local communities. As a responsible business owner, we pay our taxes, we create jobs, and I want to follow the law. But in Texas, there's no way for the retailers like me to know which vapor products are regulated and legal to sell, and which products are illegal. This lack of information creates unfair market conditions for retailers. I make every effort to carry compliant products. I should not be at a disadvantage against stores carrying hundreds of illegal imported vapor product. A vapor product directory will help level the playing field, giving all businesses the same set of rules and regulations. Senate Bill 1698 would also help my business avoid costly FDA fines. FDA has been issuing warning letters and imposing civil penalties for retailers. With millions of vapor products being illegally imported from China, retailers are at a risk of unknowingly selling illegal products. We could receive FDA fines up to $20,000 for noncompliance. A vapor product directory would greatly reduce that risk for tobacco retailers and wholesalers.
And thank you for your testimony. Senators, any questions for any of our witnesses on this panel? And we thank each of you for being here. Thank you. You're excused. Thank you very much. And Mr. Gonzalez, there you go. Thanks. We'll call J.R. Gonzalez at this time. Thanks for waiting for us. And Mr. Gonzalez is the last witness we have registered to testify on, for, or against Senate Bill 1313, 1314, 1316, and 1698. So if anyone else wishes to testify on, for, or against any of those bills, let us know now. Mr. Gonzalez, welcome. Introduce yourself.
Thank you, Mr. Chairman. My name is J.R. Gonzalez. I'm here representing the Texas Association of Mexican American Chambers of Commerce, TAMAC. TAMAC was established in 1975. We're approaching our 50th anniversary as an organization. And our primary purpose is to provide support, business leadership, and economic opportunities for our members, and to provide legislative advocacy for Hispanic businesses throughout the state of Texas. The reason I'm here today is we're actually supporting this bill, and that I've learned over the years that common sense is sometimes not that common, and this particular bill makes perfect sense. As industry evolves over time, so does the tobacco industry, and it's no exception. As we look at it, especially with the use of tobacco in our youth and other products, it's trending in the right direction. It's going in the right direction. It's dropping. But as the industry evolves and the vape products are coming on the market and the China flavored products are coming in, it's making more and more difficult. And we want to make sure that our businesses and our consumers know exactly what they're getting. SB 1698 provides a mechanism that provides manufacturers an opportunity to register e-vape products with the state, certifying that they're in compliance with the law. This bill will also allow states to certify that they are in compliance with the law. This bill also gives the comptroller the opportunity to create a list for both enforcement and to assist responsible retailers in understanding of which products to provide and are federally compliant, which ones we are not. This directive will also ensure that our state continues to have strong enforcement and regulated industry. The tools will allow responsible stone owners to self-enforce against domestic and international entities trying to circumvent the law. We hope that Texas continues to lead away with this approach. Please support SB 1698, a proposal that will provide much clarity and transparency to the e-vape marketplace. Thank you very much.
And thanks for your testimony. Members, any questions for Mr. Gonzalez?
Okay.
Senator Parker, do you have a question?
Thank you, Mr. Chairman.
Go ahead.
Just appreciate you being here and offering your perspective. So again, thank you and to everyone that came and testified. We're very grateful.
Senator Parker, thank you very much. And we're here because we feel it's important for the health of the state of Texas and especially our youth.
Absolutely. Couldn't agree with you more.
All right. Thank you, sir.
Thank you.
Thank you, members.
And thanks for being here. Anyone else wishing to testify on, for, or against Senate Bill 1313, Senate Bill 1314, Senate Bill 1316, Senate Bill 1698? So should I close testimony and then recognize you, Senator, or do you want to talk before we close testimony?
I just want to comment for a moment.
Okay, let me close testimony, then I'll recognize you. Public testimony on Senate Bill 1313 is closed. Public testimony on Senate Bill 1314 is closed. Public testimony on Senate Bill 1316 is now closed. Public testimony on Senate Bill 1698 is now closed. Senator Parker, you're recognized.
Thank you, Mr. Chairman. Members, I want to thank you all for allowing me to come before you this morning and lay out the bill. Just a couple of thoughts. First of all, I appreciate everyone that provided testimony today. It's such a crucial part of this process to get feedback, whether or not people support it or not, and I'm most grateful for that. But just a couple of thoughts. First and foremost, the federal list clearly is not working. That's what we're seeing. They're overwhelmed. They're not working. This is why we need a Texas-specific list. We've heard commentary that other states have put in place a list that wasn't successful. With all due respect, they're not Texas. We do things professionally, we do it right, and it'll be a first-class directory. And then, I want to come back and just focus on what this discussion is all about. It's about protecting our children. This is about the marketing to minors and all of the children that are being hospitalized in the state and this country every year. And far worse, there are deaths that occur because of these products as well over the years. So I just think it's very important that we recognize that and understand that what we're doing specifically with 1698 is providing education and awareness to all of our retailers to make it easier to operate a business of these products that are in fact illegal and not regulated at the federal level. So with that, I conclude. Appreciate the time to come before you, Mr. Chairman, and the members of the committee this morning.
And thank you, Senator Parker. Senate Bill 1513 is left pending at this time. Senate Bill 1314, let me back up. That was Senate Bill 1313 left pending at this time. Senate Bill 1314 is left pending at this time. Senate Bill 1316 left pending at this time. And Senate Bill 1698 left pending at this time. The chair now lays out Senate Bill 1541. 1541 recognizes its author, Senator Betancourt, to explain the matter.
Thank you, Mr. Chairman and members. After a November election and even-numbered years, the Secretary of State is required to select 4 counties at random and be audited. 2 of the counties selected must have a population of less than 300,000. 2 must have a county selected must have a population of more than 300,000. And a county selected in the most recent audit cycle may not be selected in the current audit cycle. Concerns were raised that during the interim hearing by Secretary of State's office that they can do following their randomized, what they can do effectively about following their randomized post-election audits. And simply put, what Senate Bill 1541 allows the Secretary of State to continually monitor elections for the next year and coordinate with local election officials to develop a plan to help remedy any identified issues. Lastly, if the counties do not remedy the identified issues, the Office of Secretary of State can place the county under administrative oversight. We do have that capability already for Harris County. I think Christina Atkins is here from Secretary of State. If we need a resource witness, I'd be happy to answer any questions.
Thanks, Senator Betancourt. Members, the Dean of the Senate is recognized.
Thank you.
Do you have questions? Oh, thank you, Dean. Any questions for Senator Betancourt?
No.
We'll open testimony on Senate Bill 1541, and the chair calls Ed Johnson. Mr. Johnson is the only witness that we have registered to testify on, for, or against Senate Bill 1541.
Must be House elections going on at the same time.
Is there anyone wishing to testify on, for, or against Senate Bill 1541? Seeing and hearing none, public testimony is closed.
Sure.
And the bill is left pending at this time.
Thank you.
The chair now lays out Senate Bill 2420, and recognizes its author, Senator Paxton, to explain the measure.
Well, thank you, Mr. Chairman. Thank you, members. In January, the Joint Committee to Study the Effects of Media on Minors heard witness after witness describing the pervasiveness of social media in youth culture and its harmful effects on young minds. One of the things that became very clear was that what is seen cannot be unseen. As a mother of 4 and a grandmother to 5 with 1 more on the way, there is literally nothing more important to me than protecting my kids and my grandkids. And when I was a teacher, looking out for the well-being of my students and their future opportunities. Now, in my role as a Texas state senator, I am grateful to be in a position to work on legislation that can help make a difference by equipping parents with tools that can help them protect their children. Unlike brick and mortar stores, which must verify a consumer's age before the purchase of age-restricted products like alcohol and cigarettes, minors currently navigate the expansive digital world completely without guardrails. Parents are the natural, first, and best line of defense for their child. But it's also very clear that technology companies must be good corporate citizens. Senate Bill 2420 puts an important tool in the hands of parents and some reasonable expectations and requirements on our technology companies. It is important for us to recognize that children represent a very lucrative source of revenue to retailers of all kinds. We've already heard some testimony in this direction this morning about vaping and those kinds of products. Senator Hughes, I know you will remember this past summer, the testimony of Dr. Epstein. And he talked a little bit about how in marketing to children in general, that minor children constitute one of the single largest consumer demographics. On top of that, unlike adults, the children who do have access to money to spend embody the very highly desirable characteristic of their spending being completely discretionary. They don't have rent to pay, they don't have a car, they don't have a car payment. Their money is completely discretionary, which makes them very, very desirable to those who would want to market to them. Additionally, it's been noted already this morning that some products marketed to children are addictive, such as in the bill that Senator Parker just laid out, Senate Bill 1698, regarding nicotine products. This is a precursor to substance addiction, but there are also behavioral addictions, such as screen addiction and video game addiction. There is literally a facility up north that I've learned about that provides the opportunity for youth to come to do digital detox. So, to the brain, addiction is addiction. And we have to recognize that. The research says that the younger the age of first exposure, the more likely the user is to become addicted. Obviously, the younger a user is when they are addicted, the longer they're likely to stay addicted without some sort of meaningful intervention. And it follows that the longer a user is addicted, the more profitable they are to those who market addictive products to them. The big win for those who market anything to children is the potential of creating a customer for life. Senate Bill 2420 requires app stores to verify a user's age category, to obtain parental consent for minor users, and to notify users and parents of any substantial changes to the app. It prohibits app stores from enforcing contracts entered into without parental consent, and it provides an enforcement mechanism through a private cause of action and the Deceptive Trade Practices Act. It codifies some of the age appropriateness and parental consent features that many of the app stores are already publicly touting that they do, and it will better equip parents by providing additional framework, transparency, and enforcement. I do have a committee substitute, Mr. Chairman.
Senator Betancourt sends up the committee substitute. Senator Paxton is recognized to explain the substitute.
Thank you, Mr. Chairman. Thank you, Senator Betancourt. The committee substitute incorporates stakeholder input and amends the bill to closely mirror the App Store Accountability Act, which was actually signed into law by Governor Cox in Utah just last week. Specifically, the committee substitute does the following. It titles this legislation the App Store Accountability Act. Regarding duties of app stores, it amends language to relate to how the App Store verifies the age of minors, to remove the provision requiring them to request the individual's age, and instead it requires app stores to use a commercially reasonable method to verify the age category, which is a factor that should simplify implementation. The bill requires parental consent, and in this section, language rephrases to clarify to app stores that all minor accounts must be affiliated with a parent or guardian account. It further requires an app store to obtain consent from the minor's parent or guardian through the parent account affiliated with the minor's account in order for the minor to either download or purchase an app. And it requires the app store to notify the app developer if a minor's parent or guardian revokes consent to ensure that the developer knows that the child shall no longer have access to the app and to deny the minor from further accessing the app on all devices on the family's network. Regarding the display of the age rating for the software application, this committee substitute removes the mandate that an app store displaying a rating, let me restate that. It removes the mandate that an app store display a rating, and it instead provides that if the app store has a rating or other type of content notice, it shall display the rating clearly, accurately, and conspicuously. Regarding protection of personal data, it removes language requiring app stores to delete personal data, as app stores may need long-term access to data for age verification purposes, and to collect and store data based on their own privacy policies. It maintains, however, that it still requires that data may only be used for age verification, obtaining parent consent, and monitoring and keeping compliance records. Regarding changes to software applications, the committee substitute clarifies that in instances when apps have a new version, parental consent is required again if it is a material modification to an app's terms of service, categories of data collected, stored, or shared, alters rating or content descriptions, adds new monetization features like advertisements, or materially changes the app's functionality or user experience. Regarding age verification, it clarifies that the app developers receive the age category information from the app stores and do not have to develop a new system to obtain that information separately. Again, this should simplify implementation. Regarding violations, it provides that app developers acting in good faith to receive age categories and verify that parental consent was obtained are not in violation of the Act. And it adds that remedies under this Act are not exclusive to any other actions or remedies provided by law. Finally, it changes the effective date from September 1st of 2025 to January 1st of 2026 to allow for time to implement. Parents are, again, the natural first and best line of defense for their children. But we also have a role in government to see that we are doing our best to protect the vulnerable, that we are there to support families. And part of that for us means that we need to make sure that our technology companies are being good corporate citizens. It is time for the tech industry to step up and be part of protecting kids, not just monetizing them, not turning a blind eye. And Mr. Chairman, it's about our kids, it's about reality, and it's about time.
Thank you, Senator. Members, any questions for the author before we open testimony on Senate Bill 2420? Thank you for this bill, Senator Paxton. We'll open invited testimony on Senate Bill 2420, and the chair calls John Reed, Joel Thayer, Castanita Fitzpatrick. John Reed, Joel Thayer, Castanita Fitzpatrick. Have a seat anywhere you're comfortable. The chairs are all kind of uncomfortable, but just pick any one. You're fine. Since you're ready, we'll start over here. Introduce yourself. Give us your testimony.
My name is John Reed. I'm with the Digital Childhood Alliance. That's an organization that's put together about 60 grassroots entities that care about children and are worried about technology and how it's impacting children. I spent 30 years at the Department of Justice and am a lawyer. And I want to thank you, Chairman, for allowing us to speak, and the committee, and Senator Paxton for sponsoring this important bill. I support it. Listen, for 17 years, part of me wonders where the lawyers were at these big tech companies, Apple and Google. For 17 years, Apple has allowed minors to download apps and in do that process, hit that term of service, that contract that they sign that binds the children and how their data is used, and they've not mandated parental consent. They've sat by while this has gone on for 17 years. And it's about time we do something. These contracts are one-sided. No 13, 14-year-old can be expected to understand them. They're in legalese. They obligate the child to often to have their information in their phone, their contact list, et cetera, to be monetized by the tech companies. They give permission to the tech companies to follow the child around and date stamping moment by moment where the child is in longitude and latitude so that they can monetize that data, target them with ads, and sometimes predators find that information and harm happens. And if harm happens in those terms of service, that contract, the child is not allowed to sue for the harm in federal court. They've waived that right through arbitration provisions that no child can understand. So we're here to stop that, empower parents to decide, is that app worth that contract, that obligation? And so the parent gets to decide, is my child ready for that app, and is that commitment appropriate? This actually legislates with a relatively light touch, because the way the industry is structured, almost every app is downloaded through the Apple App Store or the Google Play Store. If you have an iPhone, you're going to the App Store. If you have a Samsung or a Pixel, you're most likely to go through the Google Play Store. It's been held to have a monopoly by a jury. And so those two entities, if you can solve the issue there, you make a great benefit. The question, I think you will not hear today anyone defending the idea that these tech companies should be able to impose terms of service on minors. So the question is what we do about it. This is very privacy promoting. The information that the tech companies have, they already know if you're an adult or a minor. Your date is entered into your phone when you register it. They verify it on the back end, especially if you enter a credit card or a driver's license or the way you use and interact in your phone. So the tech companies already have it. It's an easy lift for them, and it allows parents to protect the privacy of their kids. It also, as Senator Paxton mentioned, prohibits developers from using that information to harm kids. Finally, a lot of these bills that you are going to consider to protect children, there's an argument whether it runs afoul of the First Amendment. This is designed not to. By focusing on contracts, instead of saying, here's a particular category of speech that's we're going to put our thumb on and say is harder to access, you avoid a First Amendment question. So it's designed to avoid First Amendment questions and should be enforceable quickly, not get tied up in the courts for years. I'm open to questions that the committee may have, but I strongly support this bill.
Thank you for your testimony. Welcome. Introduce yourself and go ahead.
Thank you, Mr. Chairman, for having me. Thank you, Senator Paxton, for being such a leader on this. As I said on the phone, we're a huge fan of you and your office and everything that you've done. Also, the work of this great Senate and trying to rein in big tech and make sure that they are held accountable when they hurt kids. So on that note, my name is Joel Thayer. I am an attorney and also the president of the Digital Progress Institute in Washington, D.C. I'm here to testify in favor of the App Store Accountability Act. I am also well positioned to speak on this bill as I helped develop the legal and policy framework on which SB 2420 is based. But I think before we get into that, let's begin with why we're even here. We're here to protect kids, full stop. The sad reality of the digital age is that moms and dads have been left on their own to fend off the tech industry's health crisis. Contending against the allure of products engineered by the most powerful corporations in history to be maximally addictive to kids. Worse, big tech is not only indifferent to the harms children are suffering from its products, but there is strong evidence that they actually may be perpetuating the problem. This is why the act you all are considering today is critical to ensuring parents can indeed parent in the digital age. Let's start with the underlying theories. We helped design the framework with two principles in mind. The first was that it's structured to regulate conduct, not content. It relies on a standard legal principle. Multi-trillion-dollar companies cannot enter into sophisticated contracts with minors. Make no mistake, as my colleague John alluded to, when you go onto an app store, you're entering into a contract through terms of service and through privacy policies with Apple, Google, and third parties to access a whole suite of products that usually go under the radar for most parents. Doing it this way, it comports with current Supreme Court precedent to ensure that we not just sidestep, but don't run afoul of the First Amendment at all. Keep in mind that this is traditionally how we have handled the sale of addictive products. It's why the proposal today leverages a standard legal prescription to prevent children from accessing addictive services where the onus is on the App Store to age-gate the product. When you walk into a convenience store, we require the store check for an ID when a patron purchases cigarettes, alcohol, or pornography. We also hold the store liable when kids access these products, not necessarily the supplier of the product. In other words, we don't rely on Philip Morris or Anheuser-Busch to ensure kids aren't purchasing their products. We look to CVS, 7-Eleven, and supermarkets to age-gate. The app ecosystem should be no different. I think this also dovetails into the second major principle. The framework was developed to make sure we use stakeholders' existing infrastructure and not reinvent the wheel. Indeed, placing the age-gating responsibilities on app stores reduces the cost of age verification on parents, kids, adults, and app developers, large and small. A parent simply verifies their child's device once within the App Store, and they're done. The internet is unchanged for the parent, and they are still able to control what their kid sees on their devices. Frankly, it's a win-win. Given Texas's strong track record on passing consumer protection and child safety laws, there is no policy reason why it should draw the line at contracts on app stores, especially when considering the high stakes it has on children's mental health and physical health and their overall development. In sum, the Act holds app stores accountable when they intentionally fall short of protecting children. And passing the Act is an essential step in putting families first. I'm proud to support this legislation, and thank you so much for the time.
And thank you for your testimony. Ms. Fitzpatrick, welcome. Now, since you're on the end, you got to get close to the microphone so we can hear you. Welcome. Introduce yourself and go ahead. We're glad you're here.
Okay. First, I want to say thank you. I'm truly grateful to be here, Senator Paxton and the whole committee. Hope I said that right. But my name is Castaneda Fitzpatrick. I'm from Dallas, Texas, and I'm here speaking as a survivor of human trafficking to support the Senate Bill 2420, the App Store Accountability Act. I am also an advisor to the National Center on Sexual Exploitation, NCOSE. And you know, NCOSE is a nonpartisan NGO based in Washington, D.C., and I come here from Dallas, Texas. I'm just gonna say from the heart, I was that girl. I was molested at the age of 5 years old. By the time I turned 10 years old, I was introduced to drugs and alcohol. See, that's how grooming got me. At the age of 10, somebody came up to me with drugs because see, my mother had her own life. She chose her life over me. And does that make any difference from a Apple phone or a device? No, they're still addictive. But I can tell you this, by the time I turned 11 years old, I hitchhiked from Chicago, Illinois to Cleveland, Ohio to find my mom. And my mom told the police, that's not my child, you can do whatever you want to do with her. So my traffickers and the people that exploited me, they had me for 31 years. I was out there for 31 years. And if you think about the drugs and alcohol they used me, I was in the house for like 12 weeks when they kept giving me drugs and alcohol, and a man came and pushed me in the bathroom and told me, you're not a little girl anymore, you're a grown woman. So they had their way with me for 2 weeks. Can you imagine what's happening to our children that are on these Apple phones or these devices because of the fact they groom you for things that you're addicted to? Our kids already see these devices and see these things, and they are eye-appealing, you know? And so the traffickers and the predators, they go behind the scenes to that. Our kids don't deserve to live the life that I've lived. Like I said, they got me when I was 10, and I was out there for 31 years. I'm still learning how to live life and not exist in it. My family and I are just, you know, my mom is gone now. But one thing I do want to say is I come here to raise this awareness of human trafficking because our kids do not deserve to live the life like I had. I didn't wake up one day and say, oh, I think I'll be trafficked today. I didn't wake up one day and say, you know, this is what I want to be when I grow up. I didn't have that opportunity to have a kid's life. I didn't graduate from high school. I dropped out of school when I was in the 6th grade. But once you're in that game, it's so hard to get out. And no matter if you're addicted to drugs and alcohol, thanks by the grace of God, I've been out of the life for 14 years now. And I stand on this movement, and I'm proud to walk on the side of NCOSE and Senator Paxton. I am on this movement for this bill. Since then, I just want to add to that, since then, like I said, my family and I got reconnected, but I have graduated high school in 2019 as a grown woman. I have achieved my associate's degree in 2022, and I am now starting my own nonprofit to help 18 to 25-year-olds for these young kids that's coming behind me. We shouldn't have these phones in their hands, but we should also protect them because you can't stop them, right? You know, and I was listening to the bill before me with these devices and things like that, far as the vapes and things like that. They're very appealing. They're eye-catching, they're addictive. It's just like having cocaine or alcohol. They're still an addictive agent. How do we protect our children, right? How do we protect them from that? I wish somebody had this bill going on back in 1970 when they first got me. And so in closing to what I want to say is that I am a proud Texan now. I'm glad I'm here to kick down some doors with you, Senator Paxton. I also wanted to close with this one. Here's an example of one of the apps. It's called Exposed To, that rates from ages 12 plus, and here's what the user does on these apps. They quote on the App Store, lets our users play normal, spicy, or XXX spicy modes with several options for sexual conversations and games. Based on moms and other adults, plus kids that tell me, because I'm a mentor and I mentor a lot of women, predators use apps and social media just to groom our children. The grooming stages have escalated, and they have escalated from when I was out there. It's no longer face-to-face, let me sit you down, or here, do you need something to eat, or can I give you something to drink? Because the predators use women, mother figures, to groom our children. And once they befriend you, or befriend our children, guess what happens? They have them. They have them. And so with me, they knew that I needed that love and acceptance. And so they used that against me. And for 31 years, I was out there. I was homeless until I started sexually exploiting myself because I was addicted to drugs and alcohol. But I'm proud to say that I'm no longer that. And I'm here to stand with you, beside you, and whatever you need me to do, I'm there. Thank you so much.
Thank you, Ms. Fitzpatrick. Thanks for your testimony. Senator Paxton, you have the panel.
Thank you, Chairman Hughes. Thank you for sharing your story. And congratulations on your overcoming. You're an inspiration and an encouragement, and you're taking a tragedy and you're investing that, something that looked like it was worthless, right? At one time I bet to you, it's not. It isn't. You're making it matter, and you're helping others, you're paying it forward, and we all thank you for that. One of the things that I heard each of you sort of saying is that in some ways, this bill is simply modernizing ways that we need to think about protecting children. Ms. Fitzpatrick, it wasn't the phone that got you in initially, but you see the parallel, how it does happen. And both of you gentlemen, you shared that this is sort of a modernizing approach. I wonder if you just have each of you, we'll start with you, Ms. Fitzpatrick, and go across your perspective on how this will modernize protecting our kids.
Like I stated before, I wish this was out there when I was out there, but it's giving our kids, it's giving accountability, right?
Get a little closer to the microphone so we can hear you. Go ahead.
Okay, I'm sorry. It's showing some accountability, not just on the parent side, but it's giving accountability to these app stores. Because just like the devices, they show these really pretty pictures and it draws them in, but it does show some accountability, like, hey, I do want to stand and protect our children. Let me put this on my app to make sure that this child does not get exploited, or let me do this and, to make sure that another child doesn't get, out there in the dark web and, and trafficked,
Let me also ask a follow-up question. You mentioned an app that was rated 12 plus. Could you describe that again?
Yes.
And I want everyone to listen, especially if you're a parent. I want you to listen to this description of an app that right now says that it is rated for 12 plus, and then I'd like to address that.
Yes, one of the examples, like I was explaining, is an app called Exposed To, rated for ages 12 plus, and here's what the user does on the app. Quoting from the App Store, it lets users play in normal, spicy, or XXX spicy modes, where several options for sexual conversations and games.
Thank you.
You're welcome.
Now, Any parent might assess that differently. I'm just going to say that doesn't sound like age 12 to me. Anything with triple X in it doesn't sound like a 12-year-old appropriate app. However, I did want to mention that part of what this bill will do is it will give parents a window into these descriptions. And to the extent that they are misguided or misrepresentative, I just wanted to point out that the bill specifically does give parents a way to address this. And it is a violation for an app developer to knowingly misrepresent an age rating or reason for the rating. So thank you for highlighting that. I think that's part of what this will do. It will give parents a more open window into what their kids are doing, more specifically app by app by app. And it will help them to raise their kids the way they want to raise their kids. And so thank you for bringing that up. Gentlemen, your thoughts on modernization or just how this will help modernize the way we protect kids?
Well, Senator, I couldn't have said it better myself. That's precisely what the model is based on, what your bill actually would do. What we did was we just turned, we basically said, what does the purchasing of addictive products look like in the digital age, and where are the kids getting it? I mean, your first interaction with all of these apps are the App Store. It's not, you're not going to billboards typically to find out where they are. They're getting pushed to app stores. In fact, Apple even says you must have these apps if you go on these app stores, and like a lot of them are social media apps. I mean, I wouldn't even stop at just that one app. I mean, that's one of hundreds of examples. I mean, TikTok is listed as a must-have app, and it's listed as, I think it's aged at 12 or 12 and above. And when you look at what TikTok has done, when you see the havoc it's wreaked, you wonder how in what world would that be acceptable in any other brick and mortar context? So all we really did was essentially harmonize two things. One is what is the user experience today? How are they accessing these products? And two, compliance, right? I mean, you have to make sure that you are putting the right, as my English professor would always say, the right emphasis on the right syllable. And part of that is just figuring out where the chokeholds are. And I can't say it better than my good friend at the FCC, Chairman Carr, when he says the single choke point of the mobile ecosystem are these app stores. You cannot access anything on a mobile device without going through, as you rightly said, Senator, one of two app stores. And all of this is putting the accountability where the accountability lies.
Thank you. And I also appreciate in your testimony, you said very specifically, this bill doesn't judge content.
At all.
It doesn't judge content at all. It's judging the conduct, right? And it puts the decision-making power for the content in the hands of parents.
Yes, that's precisely right.
And any given parent might think one thing is okay for their kid and another, or they may just decide, I'm just going to blindly okay everything. I feel for that child, but that's a parent's choice. So this doesn't judge the content. It's going at the conduct, and it's putting the power back in the hands of parents.
And if I may, on that one point, that's actually a feature, not a bug. The fact that it takes in every single app means that we are indifferent to the content. We don't care what the content is. What the action that we are after, the transaction that we are regulating here are contracts. And it doesn't matter if it's a social media app, if it's a digital market space, or heck, even if it's a Bible app. If there's a terms of service associated with it, kids should not be assenting to anything, especially when there's data collection implications to that, and also the ability to be digitally surveilled.
Thank you. Sir, your thoughts on the reason it's important to modernize our protection of children in this way?
Yes, so much has been said that's terrific. And Ms. Fitzgerald, I just your testimony was powerful. Let me say this. This obviously modernizes contract law that, kids can't go to banks and make a loan. Texas has a lot of other prohibitions on what minors can do. It puts that in the digital world as well. So in that sense, it's very simple. Ms. Fitzgerald's testimony was powerful, but I hope you hear other testimony about how kids are suffering today, just not with trafficking always, but just mental health issues from scrolling and the doom scrolling and lack of social interaction. As we have teenagers that are in worlds that parents weren't in. So it's hard to parent knowing what your teenagers are going through because the world has changed. And so this bill at least gives parents some insight, some power to say, my child's doing really well, that's appropriate, or this isn't going to help my child. And so the state's not deciding, the parent is.
Thank you. I appreciate, and I think that's an important point for all of us to kind of recognize. Any of us who have children or grandchildren, I mean, we recognize it's a difficult time to raise children, the world we live in. Children have always been the easy target, always, throughout history. Children are always the low-hanging fruit for predators. But one of the extra difficulties that parents certainly have today is that they're having to parent their children through things they themselves weren't parented through, right? Yeah. And I know I'm watching this with my own children who are all adults now and are starting to have their families, and they're thinking about these things, but they had cell phones. They didn't have smartphones. And it's a world of difference. And so it really does matter. We can't be indifferent to the harmful effects, as I forget who used that term, but technology cannot be indifferent to the harmful effects on children. When people are indifferent to the harm they cause, we call those people sociopaths.
That's right.
And technology companies need to be thinking about how to make things better, and I think many times they are. But we all have to do our part. We don't need corporate sociopaths. We need everyone to be on board to help protect our kids, and I really appreciate your testimony. Ms. Fitzpatrick.
I heard it said several times about the mental health aspect of it, dealing with our kiddos, and the parents are not there. They don't understand the aspect of it. One thing about trafficking and kids that go through a lot of trauma, it's an ongoing process with the mental illness. It's DID, dissociation disorder. It's not dissociation disorder. It's not just schizophrenia, and parents cannot, be aware of your children, be aware of their attitudes and their changing, their mood changings, don't just brush it off or anything like that, because you never know what your child is going through until you look into them and find out what's truly going on. Just don't stick them in okay, let me take you to the doctor. No, parent them. We don't need other doctors, because you are your kids' doctors. You know your children better than anybody. But if you watch them, pay attention to them, and see the changes in the cycle when they're on their phones and how they're dressing and what they're doing in school and stuff like that, because grooming starts when the child starts changing. And if you look at like with me, like I said before, they got me with drugs and alcohol, but even here in society today, you can go to the grocery store and you see a kid that's always walking with their head down. Pay attention to the signs. They have a man or a woman walking behind them. You're a mom, you walk beside your child. So it's a lot of different things that we can do, as you stated, Senator Paxton, as a whole, because it may not be happening in your home, it's happening right next door to you. And I'm gonna close with this. In Farmers Branch, there was two brothels in Farmers Branch, and the youngest child that was in it was 7 years old. 7, So it's not just happening physically; it is happening online, and that's how they have their attitude. The girls go to school, they have their uniform on, but what's underneath that uniform? You know? So just be mindful of your children daily.
Thank you. Thank you. And you know, that really does bring things back to, you know, first and foremost, parents have the responsibility and the joy and the duty of parenting their children. And, you know, sadly, there are many children who aren't parented.
Right.
And I'm so sorry for how that affected you and for that experience that you had. And there are many children in this situation, and that's one of the things that we have to also think about, and we do. We do consider how we can help as a state on those fronts. But for those parents who do want to parent, which is most parents, the first step is certainly awareness. And I think this will go a long way to putting some information in the hands of parents to enable them to know what's going on in their child, to watch for those signs. And I think it will make a big difference. Thank you all for coming to testify today. Thank you, Mr. Chairman.
Thank you, Senator Paxton. Senators, any other questions for these witnesses? We're thankful for each of you. Ms. Fitzpatrick, one more thing. You talked to us about some of your experiences and how we can help other children be saved from going through what you went through. And you talked about where you are today. Just give us some idea. How did you get from where you were to where you are?
One thing, I know.
There you go.
One thing is my faith in God, first of all. I got rescued August 6, 2010. Those are from the Dallas area. The PDI program saved me. They was doing a sweep that night. They was, you know, picking up all the girls and stuff like that. I prayed out to God. I was on the side of Lancaster Road with 8 pair of socks on. It was pouring down, raining outside. I said, God, please help me, help me. And 2 weeks later, they did a PDI sweep. And when they did that PDI sweep, they took me, made sure I didn't have, thank God I didn't have any diseases. I didn't have anything like that, but I was up for 12 days. And I didn't want to live this life anymore. I got tired of people using me. And I vowed to God and myself, I deserve a better way of living. It hasn't been easy. I've been through a lot since I've been out of the game and been out of the life. But I've been on this movement ever since August 6, 2010. And I wanted to go to school. I wanted to have my high school diploma. I wanted to walk across the stage and get that. I mean, I have an extensive record right now. I wish my felonies would be gone, but they're there, you know. But I live today. I don't exist in life anymore. I get to pay bills today. I can take my money, here you go. I'm just on this path now to help as many as I can. I stay determined, I stay prayed up, and every time I see another young girl that I get a chance to mentor, coming from the life, and she's doing better for herself, she either has her kids back or she learned how to ride the bus like I did, then I know I'm doing exactly what God wanted me to do. And like I said, I'm starting my nonprofit, Fly with Both Wings, and it's going to be for 18 to 25-year-olds. Because one thing Dallas, Texas does not do is when you're out of the life and you have troubles and problems, like I was in a car wreck and I needed my bills paid and I had lost 2 jobs and all of this stuff, but I don't go back to the life no matter what. I don't start using drugs no matter what, because I know if I give up, then the next girl coming behind me that's still out there, because there is another Castaneda out there. There's another 10-year-old me still out there. There's another 11-year-old me out there. So that's what keeps me going, because I'm fighting for them and not just myself.
Thank you for your testimony. Thank each of you for being here. You're excused. Thank you very much. We'll open public testimony on Senate Bill 2420, and the chair calls Vanessa Savage. Deborah Simmons. Bart Cleland. Tom Mann. Grayson G. Hi, Mr. Mann. Take that one over there. You're good. Also looking for Johnny Campus. And after this panel, we'll be calling Curry Marshall, Andrea Sparks. Have a seat right there on the end. And we'll start over here on my left, your right. Now, for those of you on the end of the table, you got to get close to the mic so we can hear you.
Me first.
Yes, sir. Introduce yourself. Give us your testimony.
Good morning. Thank you for having us here. My name is Johnny Campus. I'm Director of Telecom Policy for the Taxpayers Protection Alliance. On behalf of the millions of taxpayers and consumers we represent, we urge you to oppose this bill. The legislation presents deep constitutional issues from its mandate for device manufacturers or app stores to estimate or verify their users' age. Although well-intentioned, the bill would create substantial privacy risks and violate clear Supreme Court precedent with broad age limitations to users' right to access various digital services. The constitutionality of age verification legislation remains highly questionable. Supreme Court case law on this front stretches back decades. In the lower court's Net Choice versus Griffin 2023 case blocked an Arkansas bill requiring social media platforms to obtain age verification and parental consent to the potential violated the First Amendment. Similar age verification laws in other states have run into the same injunctions. Proponents of App Store age verification defend age proposals by saying they are about contract law, not speech. They also claim they're content neutral and therefore immune from constitutional challenge. Neither point withstands scrutiny. First, they claim the age verification bills are about contract law, not speech, does nothing to change the fact that it would impose a huge burden on the speech rights of adults forced to submit to age verification before accessing apps. These burdens ensure that the bill will fail if challenged in court. Second, a law imposing sufficiently large burdens on speech will be found unconstitutional, even if it is content neutral. To illustrate with an extreme example, a law that banned all online speech would certainly be found unconstitutional despite its neutrality. Further, the parental consent requirements of the bill run into constitutional issues. In Brown versus Entertainment and Merchant Association 2011, Justice Scalia wrote for the majority, "It does not follow that the state has the power to prevent children from hearing or saying anything without their parents' prior consent." The possibility for government...
We'll come back for questions. Thanks very much. Welcome. Introduce yourself. Give us your testimony.
Thank you, Chairman Hughes, Vice Chair Paxton, members of this committee. My name is Grayson Gee with the Texas Public Policy Foundation, and I'm here to testify today in support of Senate Bill 2420, the App Store Accountability Act. We at the Texas Public Policy Foundation have long advocated for the welfare of children and the strength of the American family. As we've studied the intersection of technology and childhood, our research has exposed a concerning reality about kids and their use of technology. In today's digital landscape, our children are more vulnerable than ever. Mobile applications have become a gateway to harm, exposing minors to inappropriate content, predatory practices, and unchecked data collection. This legislation would provide a lifeline for our children's digital well-being. Senate Bill 2420 provides what parents have been desperately asking for: real, meaningful protection for their children in the digital world. It mandates robust age verification, ensuring that app stores know exactly who is using their platforms. But this bill goes further. It protects children's personal data, limiting data collection, and ensuring encryption. In an era where children's information is constantly at risk, this bill creates a shield against unethical data practices. Some may argue that this is government overreach. I argue that it's government doing its fundamental job, promoting the general welfare of its citizens. Parents shouldn't have to be cybersecurity experts to keep their kids safe. This bill bridges that gap. It provides a framework of protection, transparency, and accountability. Thank you for the opportunity to testify today, and I look forward to answering any questions you may have.
Thank you for testimony, and I've known you for a while, but I just can't help but reverting back to pronouncing your name G sometimes. There was a judge with the same spelling that used that, but thank you, I apologize.
It's all right, sir.
And I know how to pronounce your name, but I think I did it wrong. Bart, welcome. Introduce yourself, give us your testimony.
I'll go with what you said, Mr. Chair, Bart Clellan. I like that. Happy to be here, happy to be back home. Feels great to testify. Happy to see you, Senator Paxton, and members of the committee. I'm Bartlett Clellan. I'm general counsel for a trade association called NetChoice. You guys know us, but our mission is to make the internet safe for free enterprise and free expression. Unfortunately, I have to oppose the legislation today. We do share your goal of protecting minors and any harmful content online. I personally have been involved in this fight for over 25 years, serving on a couple different commissions, national commissions, to look exactly at the right way to accomplish this end. We do ask you, that is the committee, to oppose this legislation. The Supreme Court and other federal courts have ruled that age verification mandates block access to the exercise of First Amendment rights, and that is unconstitutional. Age verification laws have recently failed in states California, Utah, Ohio, Arkansas, and Mississippi, and I would not like to have Texas to be part of that list. Given that legal landscape, SB 2420's age verification, parental consent requirements, and data-related requirements will not survive judicial review. But on the chance that they would, unconstitutional age verification laws not only face those legal challenges, but do encroach upon parents' long-established prerogatives in guiding their children's upbringing and online activities. Many online platforms, as we all know, have implemented robust parental control features already, not least of which are iPhones and iPads, an area of which I am particularly interested, that I chose to protect my children, as a matter of fact. A one-size-fits-all government mandate will give users a false impression of security and will flatten the offerings for youth safety in the future. And in the end, I'm a conservative, and I believe in personal accountability. Those peddling questionable content, we heard about some earlier today, they should be the ones called to account, not others. Thank you very much.
Thanks for your testimony. Welcome, introduce yourself, and go ahead.
Thank you. I'm Deborah Simmons, and I am for Senate Bill 2420 to require age verification for App Store downloads and purchases. In January, the Supreme Court heard oral arguments in the Free Speech Coalition case against the state of Texas. The petitioner's attorney representing the porn industry complained that Texas should have empowered and equipped parents to trust content filters rather than taking the, quote, very chilling step of requiring age verification for porn sites. The porn industry, service providers, application developers, and device companies point fingers, blaming each other, exploiting legal loopholes, and declaring that states should adopt solutions other than something that requires each of them to protect children. And then finally, the attorney scapegoated all responsibility with the declaration that parents should do better. All because they refuse to proactively share in the responsibility to protect the young and the vulnerable in society. At one point in the oral arguments, Justice Alito asked the porn industry's attorney, "Do you know a lot of parents who are more tech savvy than their 15-year-old children?" The adult entertainment industry attorney eventually conceded that access should be up to a parent to decide what's appropriate for their minor. We agree. Access should be up to the parent. Texas legislature is again supporting parents, involved and uninvolved, by blocking the downloading of applications and purchases on devices unless a minor has parental consent. It is unacceptable that the tech and content providers avoid responsibility and burden parents. This is a good bill with good intentions and an excellent mechanism to protect children and support parents. This legislation is one of the many bills that provides a common sense solution that honors parental consent supports the state's compelling interest to protect children, and provides necessary safeguards that the industry and their allies refuse to do voluntarily. We applaud the efforts of the 89th legislature to pass each and every legislation to that end. Please pass Senate Bill 2420. Thank you.
Thank you for your testimony. Mr. Mann, get close to the microphone, introduce yourself, and go ahead.
Thank you, Mr. Chair. Good morning. My name is Tom Mann. I'm here today representing the Computer and Communications Industry Association in opposition to Senate Bill 2420. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. First, we want to thank the sponsor for their openness to feedback on this bill, and we fully support your goal in protecting children online. But we'd also like to offer some thoughts today on age verification methodology. Current tools like facial age estimation are still a work in progress. The National Institute of Standards and Technology recently published a report evaluating 6 software-based age estimation and age verification tools that estimate a person's age based on the physical characteristics evident in a photo of their face. The report notes that facial age estimation accuracy is strongly influenced by algorithms, sex, image quality, region of birth, age itself, and interactions between those factors, with false positive rates varying across demographics, generally being higher in women compared to men. CCIA encourages lawmakers to consider the current technological limitations in providing reliably accurate age estimation tools across all demographic groups. Additionally, if age estimation is not used and individuals must provide their license or personal information, that means collecting more personal data, which might worry families who value privacy as much as they value safety. Recent state legislation that would implement online age verification or estimation and parental consent measures is currently facing numerous constitutional challenges, and federal judges have placed many of those laws on hold until these challenges can be fully reviewed. For these reasons and the reasons listed in my written comments, CCIA asked for an unfavorable report and appreciate the opportunity to testify today.
Thanks for your testimony. Mr. Mann, were you here for Ms. Fitzpatrick's testimony on the first panel?
I was.
Did you hear the description she read about an app that was approved for ages 12 and up on the App Store?
I did.
Did that sound to you like an app that's appropriate for ages 12 and up?
I'm not here to comment on the appropriate
Well, you are now.
individual
I'm asking,
app.
you are now. I want to know your position. I want to know CCIA's position on whether that app available today without this law is appropriate for a 12-year-old.
Our position here today, with all due respect, Mr. Chair, is that the age verification technology that would be used to verify a minor's age to get into the App Store is faulty, and that's what the reports are showing right now, that it can't be accurately verified. If it can't be accurately verified through some of these different technologies, it has to be verified some other way. So what will that other way be? Our position is that whatever that other way will be will require that minor to relinquish some more of their personal data.
So then, just a second, Senator. I'd like to know, and thanks for we're listening, it's all being taken down, we want to get the details right. If you can't tell me today, I would like in writing from you CCIA's position, your client's position. I'm curious about yours too, but you're here on behalf of your client. You and your client's position on whether the app that the witness described is appropriate for the age level that she described. Can you give that to us in writing?
We're happy to follow up with you.
Will you give us an answer in writing on that question?
Yes, Mr. Chair.
Very good, thank you. Mr. Cleveland, I know you're a lawyer. We've known each other for a long time. We've talked about free speech a little bit. I think we all agree, but let's make sure we're clear. I hope it is not NetChoice's position that the First Amendment prevents the government from protecting children. Is that NetChoice's position? I don't think it is. I just want to get that on the record.
No, that's not it at all. I'd say
I know,
actually
I know.
kind of in the reverse. The First Amendment protects everybody, and then, as you know as well from law school, there are all kinds of permutations to that.
And do we also recognize that under the First Amendment, there is speech that is appropriate for adults, but that the government is allowed under the First Amendment to limit for children? Do we agree on that?
Absolutely. In fact, most famously, pornography, for example.
I beg your pardon?
I said most famously for pornography, for example, just one of a couple different categories.
So speech that would be allowed under the First Amendment for an adult, but for children, the rules are different.
In some cases, that is correct.
And that's because if we're going to impinge on a First Amendment right, wouldn't you say that the government has to do we have a compelling state interest, and they're using the least restrictive means to achieve that interest? Is that close to the test as you understand it?
You said it well. That's close to the test as I understand. I'm not going to hold myself out as a First Amendment expert, but yes, those are some of the conditions.
Were you here for Ms. Fitzpatrick's testimony?
I'm sorry, what was it?
Were you here for Ms. Fitzpatrick's testimony, the lady that talked about her experience? Did you hear her describe an app, and she read the description of it in the App Store, which said it was for ages 12 and up? She mentioned it in her testimony, and then Senator Paxton asked her about it again in case we didn't hear it. Did you hear that testimony?
I did.
Do you believe the app she described is appropriate for ages 12 and up?
As described, my answer is no. I don't know that app, though, so I can't really speak from firsthand experience.
What is the position of Net Choice on whether the app she described is appropriate for ages 12 and up?
Well, without absolutely confirming it, I think I can speak for them and say the same as my answer, which is, as described, we would not find that appropriate for 12 years old.
Like I asked Mr. Mann, I'm going to ask you to review the testimony and respond to us in writing with Net Choice's position on whether that app is appropriate for those ages.
I couldn't hear. What was the app's name? Do you guys know what it was?
Exposed to is what my notes indicate.
Sorry, exposed?
Exposed to is what my notes indicate. That's right. But again, you can go back and watch the video, and she mentioned it twice. Mr. Campus, you probably know what's coming.
Yes, sir.
Did you hear Ms. Fitzpatrick's testimony?
Yes, sir.
What did you think about that?
That was very compelling.
What did you think about the app that she described, and she read it was approved for ages 12 and up? Did that sound right to you?
But based on what I've heard, I would say that was very questionable for minors. I would add that as a parent of a 15-year-old son and an 11-year-old daughter, and my son is autistic, so he's particularly vulnerable, I'm very much about personal responsibility as a parent to teach my children, what is appropriate and what is not appropriate. And I feel like, as a parent, my children would know that something like that is not appropriate for them.
Does the Taxpayers Protection Alliance have a position on whether that app she described is appropriate for ages 12 and up?
I would think, as Mr. Cleveland said, based on the description of it, does not seem appropriate to me, no.
Will you review the testimony and respond to the committee in writing whether your organization believes that app described by the witness is appropriate for ages 12 and up?
Yes.
Very well. Senator Paxton.
A quick question on that letter. I just want to make sure that we're okay. Given as it's described, I'm not sure I'm super comfortable reviewing the app personally, but can we respond to you as described? Is that okay, or do you want us to actually look at the app?
Counsel, we're talking about your clients here. I mean, that's an unusual position to take for Net Choice to say, I'm not sure I want to look at apps put out by people that I represent.
Oh, no, I don't think that app is my client. Absolutely not.
We'd like to know whether Net Choice believes the app she described, as she described it, is appropriate for ages 12 and up.
She described it. That's fine. Perfect.
Members, any other questions for this panel? Thanks for your testimony. Chair calls Corey Marshall, Andrea Sparks, Vanessa Savage. You have some written materials for us?
I do.
Give them to the lady right over there, and she'll get it out nice. And so we're looking, looks like we have Corey Marshall, Andrea Sparks, and then we're still looking for Vanessa Savage. Give her one more chance. All right, we'll start on my left. You're right. And Sparks, welcome back. Introduce yourself. Give us your testimony.
Thank you, Chairman Hughes, committee members. My name is Andrea Sparks, and I'm testifying in favor of
SB 2420. Thank you, Senator Paxton, for filing this bill. I'm here on behalf of a nonprofit I co-founded called Not on Our Watch Texas. Not on Our Watch is an initiative of Texas Women in Business, and our mission is to engage women in business to educate themselves and others on protecting children from online harms. When we were growing up and playing outside, we all knew to stay away from the white van, the one without the windows. When we saw one of these, we ran home to tell our mom, and we tried not to think about the dangers inside. The smartphone is the new white van. But we give these to our children at about 11 years old, and instead of being afraid, our children become addicted to them. Apps are our children's gateway to the digital world, and unfortunately, increasingly a gateway for predators to our children. We think we can keep our children safe by telling them to stay away from dangerous apps, but the reality is, once they are in the van, on the phone, it's unrealistic to expect kids to protect themselves. I want to share with you just a few of these apps that I found, and instead of reading what I think about them, I'm going to share what the kids themselves rated them. So these are kids who are literally begging someone to protect them. One app is called the Perp app. It's for 12 and up. It's described as make new friends, meet and chat with real people. Kid says, this is all full of pedophiles. This app is for teens, but I can't do this anymore. It makes my anxiety go crazy. I'm 14 and shouldn't feel unsafe on an app meant for my age group. Please figure out a way to separate minors from adults. A second app called the Buzz app. Again, 12 and up. It's described as make friends, swipe, meet, chat. There are many apps like this on here. And so I just want to thank y'all for filing this bill. Senator Paxton, it's very important. It's a common sense solution to this problem and protect our kids.
Thanks for your testimony. Ms. Marshall, welcome. Introduce yourself. Go ahead.
Thank you, sir. Good morning, Chairman, and to the distinguished members of this committee. I am Corey Marshall with the Chamber of Progress in respectful opposition to SB 2420. Chamber of Progress is a tech industry coalition working to advance the future of technology and inclusive access to that future. As written, SB 2420 would effectively require covered manufacturers to verify the identity and age of all users. In fact, estimating the age of a user will require the collection of more data. I heard Utah mentioned. It is my opinion that Utah is a one-way ticket to litigation. I know the members of this committee are fervent supporters of protecting children. As a dad of a baby boy, I am too. I just don't think that this bill is that route to where we're trying to go. This bill would absolve some companies from their shared responsibility to protect children online while placing the burden on the shoulders of a few. This bill, as it is drafted, treats app stores like gated communities and developers like the residents. Instead of making each resident individually check IDs at the door, the community gatekeeper is responsible for verifying the age and identity of everyone in the neighborhood. I don't know about you, but I'd like to make the decision on who can enter my home, not someone else. Finally, I want to underscore concerns raised by U.S. District Judge Beth Freeman in California when evaluating similar legislation. She remarked, "It's always interesting when I read the legislative history and see legislators saying, we took this idea from the United Kingdom. But here's the key difference. The United Kingdom doesn't have a First Amendment. In America, we do. And that's not just a detail, it's a cornerstone of our democracy. And it's a right we must protect." SB 2420 shifts the burden of responsibility from online safety from where it belongs and places it instead on App Store developers. For these reasons, we respectfully urge you to oppose.
Thanks for your testimony. Senator Paxton, you have the panel.
Thank you. Sir, do you have a phone, a cell phone?
I definitely do.
Do you have an iPhone or I don't know what you have. What kind of phone do you have?
Senator, I have an iPhone.
I have an iPhone also. Mm-hmm. When I set up my iPhone, part of setting up my Apple ID was putting my birthday in there. Did you do that?
I believe I did.
Okay. So I'm just going to say, anyone that has an iPhone, I believe that this is true of any phone, you put your birthday in when you set up your ID. They know how old you are. There's nothing extra required of Apple or Google to determine the age of the phone that this is assigned to. Now, if I give my phone to one of my kids, that's kind of on me. And it has my 62-year-old age attached to it. But this does not require anything extra that the companies are not already doing, and this protects kids. Again, when people do not care, individuals have no sense of care or are indifferent about harm that their actions cause, we call those people sociopaths. And companies that do that are corporate sociopaths. It is time for that to end. It is time for the tech companies to be responsible with information they already have to protect children. Thank you for your testimony. Andrea, thank you for being here. You were going to describe a couple of more apps. I wonder if you could just give us a couple more examples and what the children themselves were
I'm
saying.
going to apologize in advance. I tried to screen out the ones with the explicit language, but this was just me on my phone yesterday, looking around, getting ready for today, and I'm just baffled. I mean, if these reviews are in public and I can find them, surely the app stores can find them and do something about it, and these apps still exist. So one was called the Fizz app. It's rated 9 and up. Teen chat, meet new friends. The reviews are very dangerous for children, says one review. Another review says this is creepy, and there's some more explicit language that I'm not including. Another one was the Buzz app for rated age 12 and up, make friends. I'm a young teen. He asked me what I was wearing and asked for that type of pic, and I said no thanks. He sent a pic of himself and said he was horny and said, see you soon. I'm quite scared. So the app stores see these reviews, and there's so many. I mean, these are just from kids who are saying, help me, I'm scared. Can you take down this app? Can you do something to protect us? I think this App Store Accountability Act is just a common sense way to fix this. And like you said, the technology exists. I don't know why tech companies are opposed, except follow the money. They can tell our age to send us all kinds of ads on things that they think we want to buy. You know, you think of a pair of shoes and suddenly it's on your phone. That happens to me all the time. So, thank you.
Well, and I don't know if you were in the chamber at the beginning during the bill layout, but children are a huge consumer market, and their spendable income, because they're children, it comes from their parents, right? So that's another note to parents, pay attention. But children's income is almost exclusively discretionary. They don't have other drags on the money they have, their allowance or whatever. And so they're tremendously appealing to companies that want to market to them. And there is a lot of money in it, that's for sure. I don't think it comes to as a big shock to anyone that our children are being harvested for profit in all kinds of ways. And this is one way that we can make a difference and protect kids. And I don't hear a lot of speech censorship happening there. And this bill wouldn't get rid of that app. It would just create transparency for parents about what's there. Thank you, Andrea. Appreciate it. Thank you for both being here.
Thank you, Senator.
Thank you, Mr. Chairman.
Thank you, Senator Paxton. Members, any other questions for these witnesses? Thank you both for being here.
Thank you
very much. You're excused. Those are all the witnesses we have registered to testify on, for, or against Senate Bill 2420. Is there anyone else present wishing to testify on, for, or against Senate Bill 2420? Seeing and hearing none, public testimony is closed. Bills left pending at this time. The chair now lays out Senate Bill 517. 517 recognizes its author, our colleague Senator Middleton, to explain the bill. Senator.
Thank you, Mr. Chairman, members, for allowing me to lay out Senate Bill 517. Before we get started, I want to make clear about my intent on this bill. My intent is to ban 8-liners in Texas. And what 8-liners are gambling devices disguised as casino-like electronic video games. Their vernacular, their name is 8-liners. We see them in convenience stores, often by the restrooms or when you walk in. Of course, they're standalone operations as well, and these are spreading rapidly across Texas. These machines often mimic slot machines and other Las Vegas-style games, offering prizes based on chance and not skill. And while they're marketed as amusement, they operate in a legal gray area that has led to confusion, abuse, and inconsistent enforcement due to how the laws are drafted today. Local governments have tried to take action, some of them like Fort Worth banning them, others regulating them, but this patchwork approach is not working. Enforcement varies widely. There are loopholes that have been created by bad actors that continue to exploit some of these regulations, and what we're left with is unregulated gambling disguised as entertainment right in our own communities. Senate Bill 517 is about clarity. This bill updates the penal code to clarify the definition of 8-liners and explicitly include them as a banned gambling device and other electronic games of chance that we didn't want to catch up in this particular bill, or those that are in legitimate businesses like arcades, family fun centers like Chuck E. Cheese, where I try not to bring my kids, and other lawful amusement venues that we don't want to get swept up in the 8-liner ban. And what this bill does is it removes ambiguity and gives law enforcement and courts the tools they need to distinguish illegal gambling from other legitimate amusements. And we've heard support from law enforcement across the state who are frustrated by current gaps in the law and the proliferation of 8-liner gambling that is feeding organized crime, drug trafficking, money laundering, and other crimes. We have a lot of lists here. I mean, there was one that was busted in Cameron County that was linked to money laundering activities with drug cartels. There was another one in Henderson County, which is a fairly small county in East Texas. I think it may be in your district, linked to drug trafficking. Obviously, in Tarrant County, there was a murder associated with an 8-liner parlor there. We had one in Galveston County in Bay Cliff, where someone was murdered at a 8-liner parlor, and they actually seized the facility under a civil asset forfeiture. That's now a sheriff's substation, actually. Obviously, money laundering is another big issue that we've seen across the whole state, and overall, it's linked to this nexus of organized crime. And we are working on a committee substitute to this bill. One of the things that we want to do in the committee substitute, which is not ready to go right now, but I want to go ahead and talk about a few things that we want to accomplish with that, is in 4706, possession of a gambling device. We want to increase that from a Class A misdemeanor to a third-degree felony. We also want to add back in subchapter E of the local government code. We've talked to some police associations on that, and what that has allowed them to do is identify the operator of these facilities, right? So they have to register with the county, and this would better allow them to track those and hold accountable those that are violating the law here. Another improvement we'd like to make in the committee substitute is defining casino game displays as video mechanical displays that replicate slot machines or other casino devices. And with that, Mr. Chairman, I yield for questions.
Thank you, Senator. Senator Hall, you're recognized.
Thank you, Mr. Chairman. Help me understand, because I've talked with our DAs talked with our sheriffs about this. Why aren't they? And the answer they give me is the 8-liners are considered to be games of skill. What is the skill that they talk about that's associated with them?
Well, there's not. You know, what we've seen across the state is that they're just basically replicating Las Vegas-style gambling devices. You know,
Okay.
it's a chance, not skill.
Okay, but who is it that's telling? Who's telling the sheriffs and the DAs that they're okay? You can't do anything about them because these 8-liners are considered games of skill, and so you can't touch them from a law enforcement standpoint.
One of the problems is that they have to run sting operations, which are obviously very taxing on law enforcement. Often, you know, they'll begin in the sting operations not winning a prize in excess of the limit, which is $5 or no more than $50. And it takes a lot of time to determine that they are actually conducting illegal activities. So it makes it hard. It's sort of like the last session we passed, the catalytic converter bill, right? Where before they had to look at intent and you know, talk to the suspect, and now it's just, you see it, it's illegal, right? Possession, it's illegal. What I'm trying to do with this bill is make it more simple, right? Where law enforcement sees it, and they can stop it and also increase the criminal penalty, because right now it's difficult for them to do that with the tools that they've got in the law right now.
Okay, so you're able to define the machines in this bill as being illegal. So
right, and that's what we're working on in our committee sub to make that even more clear. There was some concerns about some of the ways that we had it defined in the as-filed version, so we want to make it even more clear that this is, you know, games of chance, and they need to be obviously held accountable for that.
Because what I hear you saying is one of our loopholes is what we currently have gives our DAs and sheriffs a loophole to not do anything about it, that they choose to not do anything. So this is going to remove that to make it, you see the machine, it's illegal.
Right, this makes it much easier, yeah.
And this to be confiscated and the operator arrested?
Yeah, so it's based on possession of the gambling device. So that's under 4706. And so, yes, the operator in possession. Now, you want to be careful, because one of the things that I talked about with my Brazoria County Sheriff here today is they would basically run these illegal 8-liner parlors, and there would be an operator not present, and then someone else was actually, you know, turning on the lights and in charge of it, and they weren't the operator. So you want to make sure that it's just possession, right? Where you're not having to prove who the operator is. We need to make sure, you know, whoever has possession of these illegal 8-liners is the one being held accountable. Where there's no kind of straw man operator out there somewhere, right, to avoid accountability.
Okay, and this isn't going to have the owner operator. Now, you got to get rid of these machines, you got to destroy them, you got to sell them. They confiscate them. Are they going to have the authority to confiscate?
They do, yes, they have the authority to confiscate
I
them,
think
yeah.
it's very important that that be very clear in the bill in order to not open another loophole, and that it'd be just like drugs or anything else. You see it, you take possession of it, take it out.
And raising that from a misdemeanor to a felony will help with that as well.
I know it worked at one time when they were able to do this. I know our jail had storage containers next to the jail, and it was full of the illegal, what were considered illegal at that time, where they would just go in and confiscate them, and then that stopped when they were told they couldn't do that anymore.
Back in the day, they used to throw the slot machines in the Gulf, you know.
Well, we're a little far from the Gulf to make that heat.
No.
Okay, thank you.
Appreciate it, Senator.
Any other questions for the author? Thank you, Senator. We'll call your invited testimony. Open testimony on Senate Bill 517, and Chair calls Honorable Bo Stallman. Sheriff, come on down. Sure, welcome. Get situated there, then introduce yourself, give us your testimony.
Yes, sir. Good morning, Mr. Chairman and the rest of the committee. Thank you for having us here today. My name is Sheriff Bo Stallman. I'm from Brazoria County, Texas. If you don't know where that is, it's actually between Harris County and the Gulf of America. It's right there. And but we're also home of the Buc-ee's as well, which is that's kind of our claim to fame. But I am here on behalf of the association, and we are here to testify in favor of this bill. And we also are thrilled for this bill, and we want to thank Senator Middleton for his leadership on this bill and for bringing this forward. As he was mentioning earlier, the game rooms that we've experienced, and these machines are within these game rooms. And these game rooms could bring about a different type of criminal element attached with it, right? So they're already operating illegally, which in turn means that since they're operating illegally, there's a lot of crimes that are actually committed within these game rooms that aren't even being reported to us because they don't want to bring any unknown attention to themselves. But I will tell you, we certainly work robbery cases, assault cases, and a few murder cases just within my county, and I know this is going throughout the state. I don't know of a sheriff, one, that would not support this bill and get behind this bill. And on behalf of the entire association, we are proud to support this bill, and we'll certainly take any questions that you have, but I do know that this does bring a criminal element to the game, and we are in support of Senator Middleton's bill.
Thank you, Sheriff, for your testimony. Senator Middleton, go ahead.
Thank you, Sheriff. I appreciate you coming down today to testify for this. I know we talked a little bit about why we need the registration to remain in there under the local government code. I think that Senator Hall touched on that. If we've got to go get those in possession of this, and you've seen kind of games of, well, who's the operator and, who's in possession of it? Could you maybe talk a little bit about
sure.
that?
So what the problem that we've had with these game rooms is that we would do these operations to determine that they are actually operating illegally. And then once you do that, then we go and seize all the games in the game room. But there's no one to hold accountable for the crimes that's being committed as far as operating it illegally. There's somebody there working, but there's no real person that to hold accountable to the illegal operation. So what we've done is we are actually rolling out a court order where it's a pass through the commissioner's court, where we make those stipulations in place, and that we're actually requiring the owner of the property and also the owner of the game, and to make sure that there's tax stamps involved and things of that nature. So whenever you do have a subcommittee, we spoke with Mr. Middleton here about not taking away or redacting that portion of it, because unless you totally get rid of all the game rooms totally, then I don't know how we can be able to effectively do this without that being in there and not retracting that portion of the bill.
And you think, raising the penalty to felony for possession would make it easier for law enforcement to enforce this?
It would certainly help to make the stakes a little higher. Yes, sir. I completely agree. Thank you.
Thanks, Senator Middleton. Any other questions for the sheriff? Sheriff, thanks for being here. Oh, Senator Hall, go ahead.
Just kind of the same question I asked Senator Middleton. What was it you were being told that led you or had you believing that you could not touch them because they were a game of skill? Different than the machines they'd had in there before, what they're using now, they are okay because they are considered a game of skill. I mean, that's what the DAs and sheriffs I've talked to have told me. Their reason for not going into today is that they have an element of, they meet the criteria for being a game of skill.
Okay, so I am not familiar with what you're saying. I don't know about pushing a button being a game of skill. That's new to me. But so I can't say that's a game of skill.
I could never figure out what they really meant.
Right. I will tell you that's something that you've never heard me say. So
okay.
Yeah.
All right. Thank you.
No problem.
Thank you, Sheriff. Thanks for being here. We'll open public testimony on Senate Bill 517, and the chair calls Lieutenant Smitty Hill, Deputy Chief Mark Barthen, Christopher Mosley. Again, Lieutenant Smitty Hill, Chief Mark Barthen, Christopher Mosley. Welcome to each of you. We'll normally start over here on my left, your right. So, council, get close to that microphone. Introduce yourself and go ahead.
My name is Chris Mosley. I'm with the City Attorney's Office in Fort Worth, and I'm speaking in opposition today to the bill. So Fort Worth opposes this bill for two reasons, although I understand the objectives, and we are completely on board with those objectives, by the way. Games that lend themselves to gambling cause crime. And the bill has, we think, some constitutional problems as it's written. In 2013 through 14, the Fort Worth citizenry came out in droves to complain about crime around game rooms. Their complaint was that businesses, whether they are convenience stores or true game rooms that had eight-liners, brought crime into the community. The citizenry demanded action. They appeared many times in council and told stories of how crime around amusement redemption machines, which they are also called, had destroyed their community. In Fort Worth, the citizenry hates the crime that gambling engenders. So Fort Worth created ordinances, we went way out on a limb, that sought to regulate where eight-liners could be. This was the impetus for 10 years of litigation, which ended last year in our victory. The game rooms argued that the occupation code, which seeks to regulate coin-operated machines, preempted the city from its regulations. Fort Worth's position was that the occupation code itself has a provision that excludes unconstitutional gaming machines. And our position throughout the litigation is that those machines were unconstitutional lotteries. Eventually, the Texas Supreme Court agreed with us. They remanded it to the Court of Appeals. We got a favorable decision out of that. The Texas Supreme Court denied further review. Our problem with this bill is under the defenses section. The bill states that skill is the predominant requirement for the player to win. This is a little nebulous. This is vague. And I believe that this would just open the door for game rooms to argue that their gaming machines are skill-based and not chance-based. Any element of chance converts a game, in our view, to an unconstitutional lottery. Secondly, gamblers and those who promote gambling and these games don't care about the sliding scale between skill and chance. They just want a foot in the door, and they want gambling, and we know what's going to happen, secondary crimes around gambling places. The part of the bill that allows gambling devices in bingo halls is infirm for all the reasons that I've been talking about this morning. I don't know why we would eliminate the local government code 234 that allows counties to regulate game rooms. And during our 10 years of litigation, we were able to work with the county to regulate game rooms, and it was an enormous help. Finally, I will just say that since 1845, the Texas Constitution has consistently prohibited lotteries and requires the legislature to pass laws prohibiting them. And that's really, really what we are interested in doing. I'm happy to work with anybody on a substitute bill, and I applaud that effort. Thank you.
Thanks for your testimony. Senator Middleton, go ahead.
Thank you, Chairman. I want to keep working with you. A couple of those concerns we've already got in a draft. There may be a third one I heard in there, but obviously we want to do the same things and
Yes.
ban these like y'all have done in Fort Worth.
Yes.
We want to make sure it's effective and good. And Section 3 is going to come out. I should have mentioned that.
Very
You
good.
just mentioned. So thank you.
Thank you, Senator.
And Lieutenant, go ahead. Introduce yourself. Give us your testimony. Welcome.
Good evening, or good morning, I guess. My name is Lieutenant Smitty Hill. I work for the Galveston County Sheriff's Office. Thank you, Chairman Hughes and Vice Chairman Paxton, and members of the committee for allowing me to be here and speak on behalf of this bill. Like I said, I'm Lieutenant Smitty Hill. I work for the Galveston County Sheriff's Office, and I'm here testifying in support of Senate Bill 517. When it comes to police work, I did the majority of my career in an undercover capacity. And a big part of that undercover work was in shutting down illegal game rooms. The problem with that being the job at the time was the hoops we had to jump through to actually shut that down. So when you look at gambling or keeping a gambling place as the offense that lists, it is a misdemeanor currently. And it also ties our hands as to what we are allowed to do on the back end of that case when it comes to shutting these places down. We also run into, there's a good reason as to why all these the people that work the game rooms are typically tied to a narcotics task force or a narcotics division. I personally have been in these game rooms. I've personally been sitting in an 8-liner, gambling my money away, and bought methamphetamine but from the person sitting next to me. It absolutely does bring upon a criminal element that the general citizens of our county do not want. In addition to that, I've personally helped on an investigation where a robbery was committed at a game room for $10,000 to $15,000, and the security guard was allegedly armed. He was armed with a fake handgun. This person, it was a shootout behind money. They stole all the money out of the safe room and, created havoc for us there for a little while. And it was a crew that was actually doing it. So this wasn't the only game room they were hitting. It was a list. Just to speed it up, and in closing, I just wanted to thank Senator Mays Miller-Levin for supporting this bill or bringing this bill forward. And we're very happy with the information contained in it.
And thank you, Lieutenant. Chief, welcome. Introduce yourself and go ahead.
I'm Deputy Chief Mark Barthen with the Fort Worth Police Department. I'm here to oppose this bill as written. Just to make clear,
Get a little closer to the microphone. Go ahead.
just to make clear, we're absolutely in support of what you're trying to accomplish, but as written, we just feel like we can't support it in this capacity. Citizens of Fort Worth have stated clearly for over 10 years that they do not want these machines in their communities. They believe these gaming locations deteriorate the quality of life in their neighborhoods. These locations frequently result in increased traffic and loitering all times of the day, and they inevitably lead to more crime. Based on my experience as both a supervisor in our narcotics and vice unit, as well as now the deputy chief that oversees those operations, I can confirm that their concerns are valid. These gaming locations result in a variety of negative impacts to the areas where they are located. They're typically 24/7 operations with people coming and going throughout the day and night. They result in increases in narcotics-related activity. They result in increases in all kinds of violent crime, whether it be shootings, aggravated assaults, and even homicides. These locations can generate thousands to tens of thousands of dollars per week, making the businesses and the patrons who win payouts frequent targets for these offenses. Nonviolent offenses like burglaries and thefts also usually accompany these locations. Enforcement under current statutes is difficult. As Mr. Mosley said, the city of Fort Worth just won a multi-year lawsuit pertaining to game machines and ordinances and regulations in which the Texas Supreme Court agreed that these machines were unconstitutional lotteries. Legalizing these machines now in certain venues and not others could result in additional costly litigation as enforcement actions are challenged. And to that note, lastly, legalizing game machines in bingo halls would essentially result in unregulated casino gambling. Bingo hall permit requests would increase, and it is my belief these locations would eventually become bingo halls in name only, as the primary source of their revenue would end up being these gaming machines. That being said, if the substitute language were to address some of those issues, I think we'd be much more favorable towards it.
Thank you, Chief, for your testimony. Any questions, Senator Middleton, for the panel?
Thank y'all for coming today. Obviously, we want to do the same things, and we're going to keep working with y'all to make sure we get there on making these just loud and clear that it's illegal. There's no loopholes. Lieutenant Hill, I was just kind of a quick question. If we ban 8-liners, we know that this is connected to organized crime. Will it reduce drug trafficking, sex trafficking, and human trafficking if we do that?
It will help.
Thank you. That's the goal. Thank y'all.
Thank you.
Thank you, Senator Middleton. Senator Hall, you're recognized.
Just really a question for everybody. If we just address this as 8-liners, is that going to leave the door open for them to come up with some other creative form of gambling? Can we not do something that puts a bigger box around it in terms of chance or something like that? Because I just imagine that they're very creative folks that do this. And time you talk very specific, my vision is a single kind of machine that we're talking about. When in reality, what we want to get rid of is gambling. We want to get rid of the gambling, period. And so I would hope we get some language in there that makes this broad enough so that our law enforcement folks won't look at us and say, well, I'm not sure whether the law lets us do this or not, like I've had told, as I've mentioned, where they know, by golly, this is illegal, this is wrong, and we're shutting it down and we're taking the machines. And so we put it into it, because you're right. It's not the problem itself. It's the culture that's around it that we need to get rid of. And they will find some, I guarantee you, they'll find something to replace the 8-liners in the thing. So I'd love to work with you. I'd love this bill. I mean, I think this is, we need this badly, but I want to make sure that our net is big enough that we put gambling out of business. We don't need gambling in Texas, period, in any form.
Thank you, Senator Hall. Members, any other questions? Senator Middleton.
I'm just agreeing with Senator Hall. I want to keep working with him to make sure we're not allowing something like a lottery courier company to spring up here in some kind of loophole where there's some kind of remote play that they can accomplish. We've actually talked about that in the committee substitute and how to prevent remote play. So I want to keep working with you on that. Thank you.
Thank you to the witnesses for being here. Thank you very much. You're excused. Is there anyone else wishing to testify on, for, or against Senate Bill 517? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. And I'll pass the gavel to Senator Schwartner to handle 3 quick bills.
Chair lays out Senate Bill 1845 and recognizes Chairman Hughes to explain his bill 1845.
Thank you, Mr. Chairman. There's growing national security concern about foreign influence, especially from countries labeled as foreign adversaries by the federal government. Senate Bill 1845 will safeguard Texas from foreign adversary influence by strengthening oversight on lobbying activities conducted on behalf of foreign adversaries. The bill expands already existing Texas lobbyist registration requirements by defining a new category of folks who lobby for, quote, foreign adversaries, foreign adversary clients, and foreign adversary political parties, unquote. These definitions are about foreign governmental and non-governmental entities designated as adversaries by the U.S. Secretary of Commerce. This includes any entity under their control, either partially or completely, as well as their affiliates and related political, corporate, or familial networks. Unlike previous rules based on expenditure or compensation thresholds, this requirement will apply universally, making sure that all advocacy efforts on behalf of adversarial interests are disclosed or covered. Not just disclosed, but addressed in the law. This bill would eliminate financial incentives for lobbying by prohibiting registrants from receiving direct or indirect compensation from foreign adversaries. And this targets potential conduits of influence such as subsidiaries, officials, or political organizations under foreign adversary control. Under the bill, the Attorney General can pursue injunctive relief and civil penalties of up to $10,000 per violation, a forfeiture of illicit compensation, and cost recovery for legal actions. This bill is about fortifying our democratic processes, enhancing transparency and lobbying, and protecting public policy from foreign interests whose interests may conflict with those of Texas and our country. I yield for questions.
Thank you, Mr. Chairman. Questions of the author? Hearing none, Chair opens up public testimony and calls Michael Lucy. Anyone else wishing to testify, please come forward and have a seat. Welcome. Please state your name, position on the bill, and you have 2 minutes to testify.
Thank you, Mr. Chair. My name is Michael Lucci. I'm the founder of State Armor, and State Armor's mission is to pursue state policy solutions to global security threats. I think that the legislation this committee is considering speaks directly to those threats. I think that the key point that this legislation addresses is that we provide adversaries an asymmetrical access point to our political system that not only do we not have into their political system, their own citizens don't have that type of access point into their political system. So if an individual in the People's Republic of China or Russia or Iran wanted to advocate for changes, many good changes within those systems, they couldn't do so. They would most likely end up in jail for doing so. On the other hand, we're allowing those adversaries defined by the federal government to access our political system, shape policymaking at the state and local level, and this gives them an asymmetrical advantage. It's a big advantage to our system overall that we are open and democratic, but when we're confronted with this sort of axis of autocracies, we have to take protective measures to make sure that they're not influencing our internal system, they're not having a vote in our internal system in a way that will damage us in the long run. I'll refer to the memo by the Director of National Intelligence from 2022. This was issued under President Biden, where it highlights specifically that the People's Republic of China has an extensive and well-developed influence operation campaign that targets state and local officials. They want to collect information, shape policy making through the business community, and generally exploit advantages at the state and local level to turn state and local policymaking away from America's national interest, taking advantage of that seam in our system where the national security expertise is at the federal level more so than at the state level. So I'll close by saying that this legislation would kind of close that loophole that gives our adversaries an asymmetrical advantage within our system.
Thank you, sir. Members' questions of this witness? Appreciate it. Hearing that, we're going to close public testimony and leave Senate Bill 1845 pending. Chair lays out as a matter of pending business Senate Bill 1860 by Chairman Hughes. Sir, you're recognized on 1860.
Thank you, Mr. Chairman. In the 88th legislature, we passed the SCOPE Act, Securing Children Online Through Parental Empowerment, House Bill 18. And that was based on the failure of digital providers to protect the safety of Texas children. It requires internet providers to implement systems to give parents greater control over their children's online activity and to prevent obscene material from being easily accessed. As a means of achieving children's safety, both in the home and in the classroom, public and charter schools were incorporated into the demands of the Act in the Education Code. Giving parental consent to software, monitoring data collection, and having appropriate restrictions to social media are a few examples of the manner in which educational institutions must comply. Higher education entities are currently exempted. The bill before us would clarify that private schools are included under the digital and TEA requirements of the SCOPE Act. That's all this bill does, takes existing policy where we considered public and charter schools, but did not specifically include private schools. That's what this bill does.
Thank you, Senator. Members, questions of the author? Hearing none, we're going to open up public testimony. There are two people wishing to testify. The chair calls Laura Colangio and Vanessa Savage. Anyone else wishing to testify, please come forward and have a seat as well. Please state your name, position on the bill, and begin.
Good morning, Mr. Chairman and committee. My name is Laura Colangelo. I'm the Executive Director of the Texas Private Schools Association. We represent the 941 private accredited nonprofit schools in the state, enrolling approximately 308,000 students. I'm here very much in favor of SB 1860. We are grateful to you, Chairman Hughes, and everyone sitting at this table for your commitment to protecting the safety of children everywhere in classrooms and online. And the SCOPE Act does that, but we request that private schools be excluded from these provisions in the same way that public schools and institutions of higher ed are exempt. What happened was in the interim, the SCOPE Act had passed and some savvy attorneys determined that private schools could be considered digital service providers because they collect personally identifying information with internet connectivity. I don't think that was the intent of this law at all. But they were quick to offer their services to get all private schools in line with these provisions, which, Google and Apple can certainly get in line with those provisions, but every individual private school does not have the technology, doesn't have the professional capacity to do that. So we don't think that was the intent of the bill. I know you'll have a long day, so I won't sit here and bemoan that fact, but if you could exempt it in the same way that public schools and institutions of higher ed, we would be most grateful, and thank you for your work.
Thank you. Members, questions? Hearing none, Chair Vanessa Savage? Is she here? Vanessa? Okay. We're going to close public testimony and leave Senate Bill 1860 pending. Chair lays out Senate Bill 2429 by Chairman Hughes. And Chairman Hughes, you're recognized on 2429.
And I thank the chair. Senate Bill 2429 is about genetic information. Hard to imagine much more personal than that for each one of us, for every Texan. Foreign adversaries, such as the People's Republic of China, the communist regime in control of that country, have identified biotechnology dominance as a critical priority for their military and their global ambitions. Bipartisan legislation backed by leaders of the House Select Committee on the Chinese Communist Party and the Senate Homeland Security Committee was introduced in 2024 to ban China's largest genomics company from doing business in the U.S. after years of warnings from intelligence officials that Beijing is gathering genetic information about Americans. A significant factor in biotechnology, of course, is access to genomic sequencing data. Senate Bill 2429 will secure the genetic information of Texans with a focus on protecting genome sequencing data. It requires medical and research facilities, as well as companies and nonprofit organizations, to make sure Texas genome sequencing data is secure through the use of encryption and other cybersecurity best practices. It also prohibits access to genome sequencing data by individuals located outside of the U.S. unless authorized by the Attorney General. It requires annual certification of compliance with these regulations and allows for civil penalties and private causes of action against entities that violate this chapter. Mr. Chairman, we have a committee substitute.
Senator Hughes sends up the committee substitute for Senate Bill 2429. You're recognized on your substitute, sir.
Mr. Chairman, thank you. The committee substitute will add an important section that prohibits any company or nonprofit from selling the genomic information of Texans in the event of bankruptcy. This is not a hypothetical, and in a bankruptcy, this is a tremendous asset held by an entity that does not need to be sold in a case like this. And I'll yield for questions and highlight that we have some excellent invited testimony on this bill.
Thank you. Members, questions? Chair opens up public testimony and calls Michael Lucy. Anyone else wishing to testify, please come forward and have a seat. Welcome again. Please state your name, position on the bill, and you have 2 minutes.
Thank you, Mr. Chair, members of the committee. My name is Michael Lucci. I'm the founder of State Armor, and we are here to testify in support of this legislation. The first point that I'd like to make is that the data privacy standards of the United States and the People's Republic of China are not only different, they're completely incongruent with one another. So whereas in the United States, at the state level and at the federal level, there are multiple layers of data protection in law as it relates to your healthcare information and specifically your genomic information. On the other hand, any company falling under the jurisdiction of the People's Republic of China must comply with China's 2017 National Intelligence Law, along with a number of other security and data laws. Former National Security Advisor Rod O'Brien wrote that this intelligence law obligates individuals, organizations, and institutions to assist the PRC security and intelligence services in carrying out a wide variety of intelligence work. So whereas we require privacy, they require espionage, and that law actually requires to deceive in the case of being caught in espionage. Beijing Genomics and its affiliates are sanctioned by the United States Department of Commerce for their involvement in human rights abuses in Western China. BGI is also blacklisted by the Department of Defense for working with China's military. I think that that point about their work with the China's military is really important, and I'll come back to what that might look like later. A letter on January 9th of this year from the House Select Committee on the Chinese Communist Party to the Commerce Department urged more action on the issue. The letter stated that the PRC has identified the flow of US IP and data to the People's Liberation Army medical infrastructure as a crucial component of the PLA's effort to dominate biotechnology. Furthermore, the letter indicated that the former president of China's National Defense University had openly discussed using biotechnology to create pathogens that could be used for war that are more toxic, contagious, and resistant. Earlier this month, China took action to prohibit the use of Illumina, that's the American genomic sequencing company, within China. Also earlier this month, the Finnish intelligence agency has put out an advisory to the Helsinki University advising against transferring any data to any Chinese gene technology company. They said that such information could, in the worst case, be exploited for developing weapons, bioweapons, that target people by their genetic code. To get to the point about the military use of genetic information, which is harvested, which Beijing Genomics retains the largest gene bank in the world. The general who ran the People's Liberation Army's National Defense University is quoted in his own book as saying, "In the development of biotechnology today, the most lethal weapons are genetically engineered weapons, designed to attack people based on their specific ethnic or racial background, causing specific races to become ill, such as suffering immune deficiency, loss of intelligence, sterilization, and even death, while leaving other races unscathed." This was published less than 10 years ago, outlining what their strategy was from a national defense perspective on using genomic information. And as the House Select Committee on the Chinese Communist Party wrote in a letter earlier this year, it's the flow of American genetic data and intellectual property that allows them to fuel this sort of military exploit. For these reasons, it's important for the state to use its really tremendous regulatory power over healthcare to just prohibit the use of these technologies and the harvesting of genomic information from our defined foreign adversaries, along with companies that are defined as military companies of our foreign adversaries and are sanctioned for human rights abuses. With that, I'd be happy to take any questions. Thank you.
Members, questions of the witness? Hearing none, we thank you, and public testimony is closed, and we will leave Senate Bill 2429 pending. Yep. Yep.
We have one bill remaining on the agenda, and there's a lot of testimony on that bill. We will, to give members a chance to get here, and a couple more things, the committee will stand at ease until 12:20. Committee will stand at ease till 12:20 when we will take up Senate Bill 30. Senate Committee on State Affairs will come to order. The chair now lays out Senate Bill 30, recognizes its author, Senator Tort, to explain the measure. Senator.
Thank you, Mr. Chairman and members. This layout is going to be a little bit longer as this bill has a number of significant components to it, and I just wanted to make sure I had a clear layout that was explanatory for the upcoming testimony and discussion, both today as well as on the floor. So with that, members, over the past decades, certain plaintiffs' attorneys have vastly expanded efforts to present inflated medical bills to juries to enhance monetary awards beyond what is reasonable, as well as manipulate the calculation juries make of non-economic compensatory damages. For historical context, in 2003, the legislature passed HB 4, the Tort Reform Bill, which included a one-sentence statute governing how medical costs are presented in civil lawsuits. This law provides that recovery of healthcare expenses is limited to the amount actually paid or incurred by the plaintiff, commonly known as the, quote, paid or incurred statute. However, certain personal injury attorneys are able to avoid the limitations of the current statute by colluding with cooperative healthcare providers who overdiagnose, overbill, and overtreat. These lawyers are able to present the artificially inflated bills to the jury, thus inflating the value of healthcare treatment, and secondarily, the value of the overall award. In addition, and further complicating personal injury cases, the compensation calculations currently in law have ambiguous and easily manipulated provisions that allow for hyperinflated, non-economic damage awards. Members, this is what is commonly referred to in the media as nuclear verdicts or jackpot justice. And since 2009, no state has experienced more nuclear verdicts at the trial court level than Texas. These factors have led to fundamental unfairness in civil trials over torts and created an unstable legal environment that forces up the cost of insuring a business beyond economic viability for some businesses. Senate Bill 30 seeks to cure ambiguities in the court procedures and the award determination process, restoring fairness and transparency to the Texas civil justice system and returning reasonable insurability to Texas businesses. The bill has four main goals. First, stop the manipulation and inflation of medical damages. Second, protect and encourage doctors who bill at rates within reason to treat accident victims. Third, provide jurors the clear definitions and instructions they need to award fair compensation for physical pain and suffering and mental or emotional pain and anguish. And fourth, create a process for a trial court to review and explain in writing higher awards of non-economic damages above thresholds. I'll talk through the main provisions of the bill at a high level and then happy to answer any questions. Under current law, Chapter 18 of the Civil Practice and Remedies Code allows a plaintiff to prove the reasonableness of healthcare charges and the necessity of services through an affidavit. A defendant may contest with a counter affidavit, but it is often a futile effort. Many courts in Texas strike the defendant's counter affidavits on various grounds, leaving the defendant unable to contest the charges or medical necessity for services provided. Senate Bill 30 replaces language on counter affidavits with a requirement for defendants to provide, quote, notice of intent to controvert to both align the law with court rulings and give plaintiffs fair notice of the defendant's intent to dispute. Additionally, because providers often refuse to treat accident victims to avoid being tied up in court, the bill provides treating doctors with protections against having to testify if service charges are already paid or below a certain threshold. The threshold in the bill is 150% of the median amount paid by non-governmental payers for the same service. Additionally, plaintiffs are encouraged to access their insurance, and transparency is improved by requiring the jury be informed of arrangements between plaintiff lawyers and healthcare providers. The bill does not set medical billing rates or prevent a plaintiff from recovering the compensatory damages if an employee's negligence caused injury. It simply returns transparency and fairness to the amounts awarded. Also very importantly, in Chapter 41, the bill amends the definition of non-economic damages and sets out standards for recovery. Doing so will codify case law and give juries meaningful guideposts, alleviating the inherent difficulty of evaluating the subjective damage awards and preventing the awarding of exemplary/punitive awards under the guise of non-economic damages. Lastly, the bill establishes a process for a trial court to explain awards of non-economic damages. This is done through a motion for remediature by the defendant. And the judge will determine whether or not the non-economic damages exceed certain thresholds, and if so, either reduce or explain in writing the legal and factual basis for a higher award. I want to be abundantly clear. This bill does not establish a cap on non-economic damages, rather a procedure to inform what the judge believed to be justification in determining the factual basis for the award and facilitate appellate review. In summary, Senate Bill 30 addresses the presentation of medical evidence at trial, improves transparency of court procedures, and gives enhanced guidance to jurors regarding the calculation of non-economic damages, thus rebalancing the scales between plaintiff and defendant. With that, Mr. Chairman, I'll be happy to answer questions. I know we have members. This is a significant bill, and for that reason, there are 10 invited testimonies, 5 on each side that will be alternated so that we can kind of hear as the discussion goes along from both sides concurrently. And then we have 60 or so individuals wishing to provide public testimony that are not invited testimony, but are public testimony. 60 or so.
Dean Zafran, you're recognized.
Yes, Mr. Chairman, as we did in Business and Commerce the other day, I would like to request strict enforcement of the rules so that when the timer buzzes, the testimony stops, since we have so many witnesses and we have session at 2, I believe. No?
We'll strongly encourage witnesses to abide by that when the time is expired. Thank you, Dean. Senator Hall, you're recognized.
Mr. Chairman, just one quick question. I had a number of folks ask me about the question of caps and whether that's constitutional or not. Do we have anybody from the AG's office here today to address that issue?
I don't believe we have a resource witness from the AG office, but the bill does not establish caps. It establishes thresholds for which the trial judge would have to entertain a motion for remediature, and if the trial judge does not remit back down to the jury the award amount, then he or she would have to explain in writing, laying out the reasoning for why remediature was not granted. It would also facilitate appellate review of the trial court's decision.
Senators, any other questions for the author before we begin testimony? Very well. We'll open testimony on Senate Bill 30, and as the author said, there'll be an invited testimony, both for and against, here available for questions, and then we'll move into public testimony. So the chair calls Lee Parsley. Jack Walker. Xavier Balderas. And Jim Perdue. So panel 1 is Lee Parsley, Jack Walker, Xavier Balderas, Jim Perdue. And I think the witnesses know if you have written materials, we'll take those from you. You may have already provided those. Welcome to each one of you for invited testimony. 5 minutes are allotted, and we will try to stay with those time limits, but there will likely be questions on these bills. So we'll start over here on my left, your right, in the order we called them. Ms. Parsley, welcome. Introduce yourself and give us your testimony.
Good morning, Senator Hughes, members of the committee. My name is Lee Parsley. I'm here on behalf of Texans for Lawsuit Reform in support of Senate Bill 30. Tort reform started in Texas in 1986 with a joint committee of the House and Senate studying the liability environment and tort laws and procedures in Texas. The committees were named by the leaders of the chambers at the time, both Democrats. The committee reported to the legislature in January of 1987, offering 30 tort reform proposals, including those related to venue in injury and death cases, statutes of limitations, comparative responsibility, limits on punitive damages, numerous other things. The Texas Civil Justice League, who I think you'll hear from later today, was created in 1986 to advocate for tort reforms in the 1987 session, and many of the things recommended by the Joint Committee passed at the time. TLR was formed 8 years later and began advocacy in 1985. Through the long-term diligent efforts of TLR, TCJL, and the entire business community in Texas, we restored sound legal principles to our state's tort laws. The goal of all tort reform bills over the last 40 years has been to guarantee fairness and efficiency in the civil justice system, knowing and accepting that those who are truly injured must be able to obtain a fair result in an efficient process. We have always sought to rein in lawyer-driven litigation, stop abuses of the system when they become pervasive, harmful to the legal system, and unfair. In spite of 4 decades of work to establish a fair and reasonably predictable civil justice system, disturbing trends in tort reform have emerged in recent years. Texas is again the nation's leading state in runaway verdicts reminiscent of the years before tort reform began. Insurance costs are increasing for every Texan and every company operating in the state. Insurance availability is shrinking in almost every sector of the economy. The increase in cost of litigation is reflected in the cost of goods and services Texans purchase. While Texas leadership have dedicated themselves to reducing the tax burden of our citizens, the tort tax is dramatically increasing. These problems are driven in large part by conduct that is, in our opinion, unethical for members of both the legal profession and medical profession. And to some extent, it results from a system that does not give jurors the information they need to make reasoned decisions. Senate Bill 30 seeks to achieve the historic goals of the civil justice system and tort laws in general, ensuring access to our courts for persons who are injured by the negligence of others, while guaranteeing a fair system for all parties involved. It's as important of a bill as TLR has worked on in its history. We are fully committed to the passage of this bill. Broadly speaking, as Senator Shortner said, the bill has 3 parts, having to do with affidavits submitted for medical damages, having to do with the medical damages evidence presented at trial, and having to do with non-economic damages. It's important to know what Senate Bill 30 does not do. Senate Bill 30 does not change the standards for succeeding in any cause of action. It does not prevent an injured person from recovering the full measure of compensatory and non-economic damages. It does not prevent a person from recovering punitive damages. It does not change the burden of proof. It does not set medical billing rates. And most importantly, it does not include a cap on damages, which I can address the constitutionality of in a moment, Senator Hall, if you'd like. It will limit the ability of some lawyers and collaborating healthcare providers to cheat. And with respect to my colleagues here at the podium with me from TTLA, many lawyers in the plaintiff's bar are cheating. In fact, I'll go farther than that. I'll say that what many of them are doing in cooperation with healthcare providers is disrespectful to juries and a fraud on the civil justice system. It needs to stop. It has to stop. If it does not stop, the Texas miracle will stop. I'm very familiar with Senate Bill 30. Some aspects of the bill will invite discussions about sensitive issues, but the delicacy of the topic should not dissuade the legislature from doing what is necessary to ensure a fair civil justice system in Texas, because a fair civil justice system benefits all Texans. This is TLR's 16th legislative session. Over 32 years, lawyers have claimed the sky is falling every time we are here working on a bill. The sky is not falling. It has never fallen. You can drive home to your districts and see the billboards and watch the television commercials and know that nothing we have done in 32 years has ended the ability of citizens of Texas to go to court and get a fair compensation for their injuries. Telling lawyers that they cannot offer knowingly false evidence in Texas courtrooms is the right thing to do for all Texans. Thank you.
Thank you for your testimony. Mr. Walker, welcome. Introduce yourself and go ahead.
Thank you, Mr. Chairman. My name is Jack Walker. I'm the president of the Texas Trial Lawyers Association. I'm here today with my colleagues to testify in opposition to Senate Bill 30. Senate Bill 30 is not just one bill. There are 4 sections to this bill that we will testify to today. In my time before you, I'm going to go through each section, identify the subject, and give you a brief explanation of what it contains. My colleagues will then go through in more detail, identify the issues in each section, the dangers they present, and why they won't work. So let's start with section 1. We'll call this the medical expense section. This section redefines how medical expenses are proven and valued at trial. In many cases, this is going to limit damages to 150% of a threshold. These are not market rates, they're administrative rates. This creates a cap on damages disconnected from actual medical costs. In some surgical cases, this cap would reimburse less than 50% of what the surgery costs. So if this cap are applied and you're at trial, the plaintiff is found, the defendant is found negligence, the plaintiff is found to get damages. If the cap is applied and it's 50% of the cost, the plaintiff, having won, is still going to be responsible for a large portion of the bill, even after being the victor. Now, Section 2 purports to redefine non-economic damages. This is perhaps one of the most damaging parts of the bill. What this does is completely guts non-economic damages recovery and will devastate the most vulnerable, catastrophically injured victims. Texas currently recognizes at least 6 elements of non-economic damages: pain and suffering, mental anguish, disfigurement, physical impairment, loss of consortium, loss of enjoyment of life, and these are important. These damage elements were developed at common law over time to cover the full range of human suffering that can result from these serious injuries. Senate bill guts these definitions and reduces it down to 2, physical pain and mental anguish. And then what it does is it then raises the bar. It redefines mental anguish and physical pain so narrowly that they become almost impossible to prove. This redefinition is not designed to clarify mental anguish or clarify physical pain. It's actually meant to disqualify it. The result is simple. SB 30 reduces human suffering to a checklist. And if you don't check the right box, your pain and your mental anguish is worth nothing. I'll give you an example. A victim who's been permanently burned in an industrial accident will no longer be able to recover for a lifetime of disfigurement because it's been stripped out. A victim who at the age of 25 has her leg amputated as a result of a defective product will not be able to recover for that lifetime of physical impairment. Now we'll go to section 3. I'm going to call this the disclosure section. This is perhaps the most bizarre section of the bill. This forces disclosure of irrelevant information. It requires disclosures of letters of protection, referral relationships, financial arrangements, all of which are not relevant to the actual issues in the case. But the bizarre thing it does, then after it's disclosed, it mandates that all of this is admitted into evidence with no judicial oversight. It is completely one-sided. There's no additional obligation on the defendant to produce anything. It only applies to the plaintiff. An example of this is the referral relationships between doctors and lawyers, okay? Now, this has been a subject of the first part of the bill, but I'll give you this. I was raised and still live in a small town in Tyler. I send people to doctors all the time. My father's an orthopedic surgeon. Somebody comes to me and says, I've got a foot and ankle problem. I say, go see this person, they're the best. Go see this person, the best. Under this bill, if I do that, then I have to go back for 2 years, figure out if I've ever sent somebody to a bill, and then send to the doctor, and then I gotta disclose the amount of money that my office has paid to pay the bills of my clients. It's not about transparency. It's about tilting the courtroom against injured Texans. Now, finally, I'm going to take issue with Mr. Parsley, as you thought I might, about the non-economic damage caps. This is a cap bill. Do not be fooled. The Texas Constitution guarantees a right to trial by jury, not trial by formula. This remitter scheme in this bill allows a judge to override a jury's verdict based upon artificial caps and not the facts of the case. The bill doesn't just limit damages, it rewrites the jury verdict after the fact. That's not reform. That's an unconstitutional intrusion on the jury's core function. The jury is the sole fact finder. A judge has no ability to overturn it. We would ask that this bill not be passed. Thank you. I'll answer any questions you have about any section of the bill.
Thank you for your testimony. And I'll say, unless the senator feels otherwise, we'll hear from each witness, then I'm sure we're going to have questions. Mr. Balderas, welcome. Introduce yourself. Give us your testimony.
Thank you, Chairman Hughes. Good morning, Chairman Hughes, or good afternoon, I guess, members of the committee. My name is Javier Balderas. I'm Associate General Counsel to CRH, who ranks 112th on the Fortune Global 500 list. We're the largest worldwide supplier of asphalt, aggregates, ready-mix, concrete products, and cement. In Texas, CRH's federation of companies include Texas Materials Group, Jewel, Old Castle Infrastructure, Ash Grove, and Leviat. Texas is our #1 growth target in the U.S. and has been for several years. Since 2020, CRH's Texas companies have invested over $2.8 billion in acquisitions and over $430 million in capital expenditures. CRH's Texas companies are involved in large highway and infrastructure projects throughout the state, including construction of the $17 billion semiconductor plant in Taylor, Texas. Texas courts and current legislation have created a fertile ground for lawsuit abuse. Today, Texas is considered among the worst states in which to litigate, with Harris County one of the worst counties in the nation when it comes to jury awards. In Harris County, a case with a jury verdict of $100,000 in 2020 could now easily reach a jury verdict in excess of $2 million in 25. CRH's companies prioritize performance predictability, and the current Texas legislative landscape is riddled with those variables. The feeding frenzy for the next nuclear verdict has dramatically increased the number of claims that go into the lawsuit stage. Prior to 2020, in Texas, and by the way, I should have stated that I handle litigation west of the Mississippi, so I have a good snapshot of what the west, everything west going all the way to Washington, going all the way to California, and what have you. And in that time frame, prior to 2020 in Texas, approximately 30% of my cases would go from the claim to petition stage. In Texas, in 2021, the number of claims going to lawsuit since 2021, the number of claims going to the lawsuit stage have dramatically increased. So 80% of the claims that I'm seeing right now coming across my desk are going straight to litigation. For companies such as CRH's Texas Materials Company and its other federation of companies, the general percentage in the West is not in line with what we're seeing throughout the West. Right now in the West, we are seeing somewhere closer to about 40% of claims are going to litigation. So what does that do? It places a huge number of cases in the Texas state court system that are not capable of handling such caseloads. More importantly, loopholes in the current Texas state law, which SB 30 aims to close, provide plaintiffs' bar with an extraordinary mechanism or extraordinary number of mechanisms for achieving nuclear verdicts. So how do nuclear verdicts affect CRH's Texas businesses? In the last 4 years, insurance costs have increased for us by 71%. Those increased costs snowball from lower tiers through us to ultimate private and public owners, including TxDOT, drastically increasing project costs. Our biggest impacts involves our outside haulers. When they can't afford astronomical insurance costs, it drives those owner-operators out of business. And that's the same factor that's happening with small businesses, even that don't have trucking components, that have just general liability policies. It's driving those small businesses out. And this has put severe strains on the already strained trucker shortage and small suppliers. It also is going to have an effect on those DBE businesses that need that extra business. So due to the volatility of the Texas landscape, we're having to make pragmatic decisions as to new M&A opportunities, capital and capital expenditures. CRH and its subsidiaries now increasingly look at opportunities in other states where litigation risks bring less volatility. 5 years ago, it would have been unheard of to look at California and Washington and Colorado as more attractive areas to be able to grow CRH's businesses. And today, we're having to make those hard looks at other states that have traditionally been more volatile. Right now, Texas has that volatility first place. For Harris County alone, we've had to pass on what would be otherwise attractive acquisitions because those risks are far too high. That same risk assessment is occurring throughout countless other companies. So the Texas legislature now faces a true crossing the Rubicon moment, reining in nuclear verdicts to prevent disastrous effects on Texas businesses, both large and small. CRH urges this body to pass SB 30 to make Texas a place where business can flourish. Thank you.
Thank you, Mr. Balderas. Mr. Perdue, welcome. Introduce yourself. Give us your testimony.
Mr. Chairman, members of the committee, my name is Jim Perdue, Jr. I'm a lawyer in Houston, Texas. I've been practicing some 31 years. I was the past president of the Texas Trial Lawyers Association. I had the pleasure of appearing in front of many of you in the 2021 session. Thank you for having me back. Let me begin by saying, with the fundamental proposition, I think there are people on either side of this bill who can be described as well-intentioned. I don't think that some of the observations regarding medical billing evidence you're going to hear from me on today anyway, but I understand some of those concerns. I understand that industry brings to this body concerns regarding certain aspects, but we have heard anecdotal stories regarding an insurance marketplace across all lines of insurance, depending on which committees you're serving on this session, in both houses regarding the affordability and access issues for insurance across all lines, because it's a nationwide issue. Nothing in this bill specific to my comments today regarding the redefinition of non-economic damages has anywhere ever affected insurance availability or insurance affordability. What this bill represents in Section 3, it's really Section 2 of the areas to discuss today, but Section 3 of the bill itself, is an effort to use a few definitions within Chapter 41 of the Texas Civil Practice and Remedies Code, which was drafted, I will say, in 2003 as part of HB 4 by TLR in part of the big bill. So the definition of non-economic damages that exist in Chapter 41, 111 of non-economic damages was written by TLR in 2003. What is occurring in the bill today is to take the list of non-economic damages that have been recognized in the Anglo-American jurisprudence system of common law from the time that the Magna Carta moved through civil law in Europe and came over to our American history. The definition of damages when it comes to civil accountability, which evolves because that's what the common law does, but that tradition which has been honored of the courts looking at those things, changing the definitions, writing those definitions through case law, and putting the parameters on them, have led to, as Mr. Walker said, essentially 6 areas of non-economic damages which have been recognized and I will say have been validated by the Texas Supreme Court and a unanimous 9 Republican-member Texas Supreme Court over and over again. And in fact, one of the redefinitions would repeal a Texas Supreme Court opinion written by Justice Priscilla Owen, who went on to become chief of the Fifth Circuit Court of Appeals, joined by Chief Justice Hecht, joined by Chief Justice Phillips, that tried to give common law parameters to these definitions of non-economic damages. And this bill repeals that case by the Texas Supreme Court from 2003 and redefines, fundamentally redefines, the way we look at and understand non-economic damages to be. And then, Mr. Chairman, in the redefinition, because of the way they've redefined two areas of non-economic damages, that the world of non-economic damages that recognizes human pain and suffering and loss of a loved one and the care and support they provide, and physical impairment for someone who is an amputee, who you may hear from today, and recognize the change that affects in their life, and the mental anguish that is associated with bearing a child or suffering an injury for which there is no recovery. Those things have been recognized for over 100 years in the state of Texas as elements of damages that are subject to recovery. Now, this is a question of, they keep suggesting that there is essentially an attempt to write into the law, current law. The redefinition as exists in 11A, page 6 of the bill, does something that is noticeably incongruent with current law, Mr. Chairman. So they take a definition of mental and emotional pain or anguish, and they add grievous or debilitating angst, distress, torment, or emotional suffering. And then, in a clever fashion, they add causes a substantial disruption in a person's daily routine, and then add a conjunctive and. That is, that it must be two things to qualify. That's a cap of 0 on a rape victim. That's a cap of 0 on a parent who has buried a child for mental anguish. And therefore, we respectfully oppose the bill. I welcome any questions.
And thank you for your testimony. Members, any questions for any of our witnesses on this panel? Senator Perry?
I'm not sure. Are we going to have any medical personnel not invited?
There's not in the invited testimony, Senator. There's 10 individuals, primarily from Tort side as well as the defendants.
That's fine.
Senator Perry,
There will be a lot of testimony that will have some provider.
Yeah, there's some docs in some of the public testimony, but not the invited.
Well, it's part of this bill, but it's not part of this bill. But we're chasing dollars that are not real, in the sense that, and it goes to the heart of redefining a compensation base, if you will, on what we're going to base it on. But and maybe y'all know, I don't care if any one of you can answer it, and if you don't know, let the medical professionals tell us, but there's the master billing code, and then there's what you pay code, right? This is a black box that the medical profession chooses not to disclose, be it hospitals, insurance, or otherwise. So if Charles Perry's heart attack cost me $180,000 on paper, but ultimately all parties involved in fixing my heart attack that day was $21,000. The question of the day is, do you take the 180 to the jury, or do you take the 21 to the jury? Anybody know or want to answer that?
I can answer that, Senator Perry. So the way it's structured now is you have private health insurance that has previously negotiated certain rates for the cost of a heart attack, including the provider, including the hospital, and that sort of thing. That bill, when it's paid, is what's submitted to the jury. Under this bill, if you were uninsured or it was not covered, it would be tied to under the bill, it's tied to a database that is actually not available to determine what the billing would be because it's not funded and it's not around. Or I've been told it would be tied to 150% of workers' compensation. Either way, it would not be tied to the actual value of the service that you received.
Well, I think...
Senator Perry, can I...
Yes. Go ahead, Lee.
Your question was, which one of those is the medical billing tied to? And the answer is neither of them. So the way this works in litigation is that you go into a plaintiff's attorney's office, many of them, not all of them, and they send you to their favorite treating chiropractors, physicians for various things. And those people bill whatever number they want to put down on a sheet of paper, having nothing to do with what you just described. They bill whatever number they want to put down on a sheet of paper, and that is sent to the jury as if it's legitimate medical bills. It is not tied to any of those things you described. So the reason, I agree with what Jack said, is if you send it to medical payment, in your Blue Cross or whomever pays it, then the jury hears the amount that Blue Cross or whomever the insurance company, they'll hear that amount that was paid. But the lawyers who do this kind of work tell their clients, do not use your health insurance because it limits your recovery in trial. It both limits your medical recovery and it limits your non-economic damages. Do not whip out your insurance card, period. Go to my person and don't use insurance, because my person's going to write down a number that is 5, 8, 10, maybe 20 times what Blue Cross Blue Shield would pay for that service. And that's the number we're going to give to the jury. And that's what this bill is about. When I say it's fraud, it is made up medical damages for the purpose of inflating damages at trial. It just is, and it happens every day all across Texas, and it has to stop. That's what this bill is about.
So to be clear, there's no standard today that when you go to court that it is based on actual cost. It's just whatever the medical profession sends in for their documentation. It's not questioned. It's not looked at as reasonableness. It's not tied to anything in the market.
It's subject to cross-examination at trial, but it is not tied to anything.
As a practicing lawyer, Senator Perry, I would tell you how it works. Currently under the system, there is an affidavit system, and it's 18001 in this bill. And as it currently stands, if you have a bill, you get an affidavit from the medical provider. They swear out that that's reasonable and necessary, and you submit that to the defendant. If the defendant takes issue with it, they have an opportunity to file a counter affidavit and say, no, we disagree with that. So it is, and this is what we think the bill should be. Okay, so it's not what's ever put down goes automatically to the jury. That's not how it works in any sense.
Well, it does. You're entitled to present it to the jury, Jack, and you do present it to the jury. It's subject to cross-examination, but it is presented to the jury. There's nothing that stops it. So this bill ties it to paid claims. That's the purpose of this bill. It ties it to paid claims for the first time, which it is not today.
Here's where you're mistaken. When you file that counter affidavit, my affidavit is gone. It is no longer good. Okay, I then have to go bring medical evidence into the courtroom of whatever bill I'm going to do. So it doesn't come in. It's not even subject to cross-examination. You have to go in and get it put in some.
So I'm listening to you guys, and y'all can debate each other outside the hallways.
Right. Fine.
So to be clear, and I'm trying. This is an important nuance to this conversation. There's really, and the bill seeks to establish a standard. What I heard both of you say, for different reasons, there is no standard. Is that true? There's no, it don't even start with master billing, which is, don't get me started on that. There's no standard. It's whatever the physician signs off that this is what it's going to take, regardless of what practices and actual payments for that same issue at the end of the day through a negotiated contract insurance companies make with hospitals and physicians. There's none of that objective point to say that neck injury cost $173,000 and that's universal amongst 20 providers. There's nothing you can point to that is claims paid in the industry. Y'all are saying, one says it's whatever it wants to be, and you say we get a doctor to sign off on it, and it could be 4 times what the average payment is for that, correct?
Yes.
Okay, thank you.
Senator Shorter, go ahead.
I think that's an extremely important point for the members to understand. As a practicing orthopedic surgeon, the current ruling standard is paid or incurred charges for the injured individual. But because plaintiff firms do not utilize health insurance and actually instruct their injured clients not to utilize health insurance, and in addition utilize a network that they themselves kind of control, everything is incurred. And so the incurred charges in your case You said a heart attack, but it'd be more likely like an injured something might be $100,000, whereas health insurance might reimburse $5,000 or $6,000 for those same things. But what is considered in the deliberation of the court is the $100,000 number, not the $5,000 or $6,000 number that would be paid by a third-party health insurance.
I think it's really important that we understand that nuance. And now we'll go the other side. I'm not speaking to the other economic damage conversations that you raise in both of y'all. I'm saying specifically to the medical charge. The amount of money that if it wasn't for injury and in a lawsuit, that injured person's insurance would be expected to pay, or if they're non-insured would be expected to pay, which usually there's a significant cash discount or workout, right? So that's an important piece of this piece of legislation that had it been tied to the negotiated contracts across the country for hospitals and medical providers, there's a pretty significant, like I say, they charged me 180, they ended up taking 21 as providers. That's kind of normal throughout the hospital industry.
The differential could be even greater than that in
Right.
cases of personal injury cases.
Yeah, so I appreciate that.
I, again, want to reemphasize the current standard utilized in law is paid or incurred when it comes to medical. Is that correct, Mr. Walker?
That is correct.
That's correct. Mr. Parsley. And therefore, the changing in this legislation is one in which it ties to either what was paid or you can go above 100 or what is actually not incurred, but 150% of a threshold. You can bill what you want, but if it's above 150% of a threshold, then you have to legitimize it by putting yourself at risk as a provider to come before the court and make it legitimate as far as the cost of those services. That's what the bill currently does in its written form. Mr. Parsley, you agree with that?
Well, for incurred bills, for paid bills, the law will be the same. It's been since 2003. The jury hears the amount paid. For incurred but unpaid bills, this piece of legislation would base those on a market rate. That is, you would look at the database, you would draw from it the average amount paid for that service during the month that it was provided to the person, in the area it was provided to the person, and you would take the average of the amount paid by private payers, so not the government payers, but private payers for that service, and then you would multiply times 150%, and that would be the limit on the damages that you could get, 150% of the private payer's average amount for that service. That's what this bill provides, so that it is not just an unlimited amount potentially awardable in litigation that is not related to the market.
Mr. Walker, go ahead.
Mr. Parsley and I had a conversation about this a few days ago. The issue with the bill is the database that's contained in the bill does not exist for the purpose of which it's stated in the bill. There are databases out there that do take non-governmental negotiated rates and find averages that can be used. This one doesn't exist for that purpose.
And if I can ask a mechanical question to follow up on this, we're talking about paid or incurred. So for those bills that are incurred but not yet paid, and Mr. Parsley, you talked about situations where the lawyer and the physician have a relationship and health insurance is not used. For the disclosure part of the bill about referrals and things like that, is that so that there can be a determination made as to whether the plaintiff has a relationship with the lawyer and the physician, or is that what that's about? And does that have any effect on this? For example, if someone didn't go to the doctor through their lawyer and doesn't have health insurance, but they've incurred this bill, are they affected by this too? Or is that what and I don't know the answer, it's a legitimate question mechanically, or is that what those disclosures are for, to figure out which category this person falls into?
Thank you, Senator. Let me address that.
That was a terrible question, but you know what I'm trying to ask, I think.
I think so. Let me address that a couple of ways. It is based on the Florida legislation. Florida has done this in 2023 because this problem is not limited to Texas. So Florida makes the same disclosures and makes the things admissible into evidence. So the agreement between the lawyer and the healthcare providers is disclosed and admissible in Florida, and as is the relationship. So if it's a referral network, the lawyers refers to the providers, then that's admissible in Florida. It's discoverable and admissible. So they passed that in 2023, and they did a similar thing in terms of their medical damages based on Medicare and Medicaid rates instead of a private payer system. And so it is, we believe that, frankly, jurors need better information. They just need to know what's going on in the context of this case that's come to them. And I think it is relevant to jurors to know that this lawyer and the healthcare provider work together all the time, and the medical bills may reflect that. And so that's, I think, why Florida did it and why it's in this bill as well, is that the jurors need to understand the full context in which this case is in front of them.
Oh, Senator Perry, go ahead.
You finish?
No, thank you. So, and I think I see what you're saying. And so, in it, and I don't know how the Florida bill works, in a situation like that, if a person, if the disclosures, there's no evidence that there's a relationship between the lawyer and the doctor, and the person doesn't have health insurance, but they've incurred these bills, would the formula still apply to them, or is there how does that work?
Yeah,
My situation being a plaintiff is uninsured, person's uninsured, and they owe this medical bill not to a physician who has a relationship with their lawyer, but someone who's uninsured, so they didn't choose not to use their insurance, they don't have any, right, and they have this bill that they owe. What would, and I don't know the answer, how does that flow through?
I think if I'm understanding the question, the answer is that if the person is injured, they're uninsured, they go see a lawyer, the lawyer has nothing to do with their medical treatments, they just go to a doctor, they receive medical treatments, then there's nothing really for the jury to hear, and certainly nothing that's negative about, I'm sorry.
It's for private payer.
Go ahead.
It's a private payer issue, correct?
Right. Well, that's what I'm curious about. Just from the discussion here, I just had that question.
So I'm still not sure I quite answered the question, but I think the thing is, there's nothing really, the jury could hear that this person went and received medical treatment from someone who was unrelated, that was referred to them by their sister and somebody that's treated them for decades or whatever. And the jury could hear that under this bill, and I think that the jury would be heartened by that. And then on the other side of that, if the person is uninsured and went to see a lawyer and the lawyer referred them to a series of people over time with whom the lawyer has worked for years and has a fairly close financial relationship, the jury's going to hear that too, and the jury may not be heartened by that. But either way, I think the information to the jury is potentially meaningful.
Senator Perry, go ahead.
So I think the question, if don't want to put words in your mouth, for those that don't have insurance that are injured in the court, does the chart for the insured average claims paid, once it's determined what that chart is, apply the same as if it would if you're a private payer? Is that what you're asking? Yes, sir. So basically, if I'm injured, no insurance, and I go out and have the same procedure, same surgery, is the chart that serves as the database going to be the same standard for the 150% metric under a private payer? I paid for those services personally, or I need to personally because I'm uninsured. Is that database going to reflect the same metric?
If you paid for the services under this bill, if you paid for the services, then the jury will hear the amount you paid. Okay. It won't be the 150% metric.
Well,
so it's
incurred.
only incurred and unpaid.
Is the same chart going to apply to both a private and an insured?
It is.
Yes.
Okay. Secondly, my question was, you, Mr. Walker, made in your layout, and I want to make sure that I was clear on it. You kind of went to possibly HIPAA violations, kind of in your layout. Now, to be clear, the actual medical procedures and the nuances and the intricacies of that person's treatment that could be you said personal, I think, what was the word. Yeah. That's not what the jury's going to see. It's going to be comparing it to the database for a, quote, diagnosed or procedure that's standardly.
Are you talking about the database, whatever it may be?
You said something in your layout that you gave me the impression that Charles Perry has an injury. It's got really weird stuff applied to it, and the diagnosis, and that all of that was going to come out in public record.
Okay. Well, I don't know if I said that, and I'm under which context. There's two contexts I talked about. One of them was under the disclosures, okay, and that was if I were to make referrals to local doctors, then I have to give up the amount that I've paid to those physicians. I mean, to those physicians in the disclosures. It's as I understand, it's not going to be the medical records. It's just going to be the amounts paid. So that's not. It could be there could be HIPAA issues there because of names and that sort of thing. I did not hit on that, and that wasn't the purpose.
So to be clear, we're not asking a physician or provider that you have that arranged with or not from violating HIPAA by having to disclose stuff in that trial process.
No, but one of the things in that disclosure, I called it a bizarre part of the bill because of this. One of the disclosures is you have to give up all of the medical records that you've had with someone for however long you've treated with them. If you treated with your physician for 40 years, okay, under this bill, if you're in a car wreck and you hurt your back, all of the records from that physician, no matter what they're related to and no matter how far back they go to the defendant. Here's the other issue though. Because they're in that disclosure requirement, they automatically come into evidence. One of the main concerns we have about this disclosure requirements, and with all due respect, whether or not that Mr. Parsley thinks something's relevant and the jury could do it, would like it, or not relevant, that's the job of the judge. And this bill takes all of that away. All of this information we're talking about is a directly gateway into evidence. And so it takes away the judge's ability to look at it and see if it's relevant. Look and see, well, did this patient, how did they get to the doctor and do this? It just comes in automatically.
I appreciate that clarification.
Okay.
Thank you.
Senators, are there any other questions for the witnesses on this panel? Dean Zaffarini, you're recognized.
Thank you, Mr. Chairman. Mr. Parsley, you referred in your testimony to cheating by trial lawyers. Is that something that you have anecdotal evidence? Is that something that has happened, perhaps occasionally or rarely, or are you saying that that's prevalent?
I think that you'll hear a number of witnesses come today who will talk to you about their experience in litigation, and they will tell you what they have seen, and I think that it will qualify as the actual evidence you are looking for about what I referred to as cheating by the trial lawyers. I think that it has become rampant in this industry right now, that for cases, the run-of-the-mill cases, I'm not talking about the catastrophic injuries, but the run-of-the-mill fender benders, that the lawyers are feeding the clients into the system of healthcare providers who treat them. And the internal thing that's going on here that I think is just inappropriate, frankly, is that it is designed to run up the medical bills for the purpose of damages in litigation. It's not designed to treat the person for a problem. And I think you'll hear a lot about that today. And if you're not satisfied with it at the end of the day, I'm happy to come to your office and do more. But I do think that there is, you'll hear a lot of evidence about that today from people who are engaged every day in this process.
Thank you. Mr. Walker, would you like to respond, or Mr. Perdue, either one?
Go ahead. If I could respond, Dean, because I think a point was just made that's really important.
Right.
I think a point that Mr. Parsley just made in response to your question is really important, which is the proposition that this bill is designed not to affect those who are catastrophically injured, not to limit the rights of recovery of people who have been run over by a truck on I-35 and lost 3 children, not to take away the rights of people who, from the woman that we heard earlier today, who is a survivor of being sex trafficked, and the liability that may exist there. Unfortunately, in the effort to capture this issue of medical expenses, they have combined it with the definition of limiting damages on exactly those kinds of cases. If they were looking at the lawsuit industry and trying to talk about people gaming the system, then there would be absolutely no reason to have these redefinitions of non-economic damages and caps the way it's written. Those go to the heart of the people who are most injured, the most catastrophically injured. And if we could have that disconnect, we could have a conversation. But this bill in its heart is designed to go to exactly those kinds of cases and not the small cases.
Thank you. Mr. Walker, in your testimony, you referred to Section 3 as bizarre.
Yes.
And you said that it mandates no judicial oversight and it applies only to plaintiffs. Could you expand on that, please?
Yes. So The disclosure requirements, I can go through and look at what it requires, but as I stated, it requires that you produce all of your medical records and your invoices. You produce all LOPs, all agreements, all third-party agreements, which is really not a problem. But when you get to the attorney referral information, it gets a little bit dicey because of what I talked about. But I want to talk to you about other things. It requires and it admits your health insurance information, your health insurance policy. We have a rule in evidence called, I just drew a blank on it. Collateral source rule, that for years, insurance doesn't come into the case because it can prejudice the jury. Now, it's automatically admitted. It also admits workers' comp treatment guidelines and drug formularies. Has nothing to do with the case. But all of this information, all of this bizarre disclosure that you have to give from the plaintiff side comes into evidence, nothing from the defense side. Okay, and there's no gatekeeping. The judge has no right to say, wait a minute, that's not relevant. That's prejudicial, which is the job of the judge. That's taken away from the judge in this. Okay, it's to tilt the table in favor of the defendant. The defendant didn't have to do anything. They just produce it all and put it all into evidence.
And this is to anyone who would like to answer. How does the redefinition of mental anguish impact the process?
I'm going to let that's Mr. Perdue.
Impact the process?
Impact the process.
Yes.
So what the redefinition of mental or emotional pain does is capture language that does not exist in current common law because it elevates it and it makes it a conjunctive. So you take the sex trafficking victim, you take a rape victim, you take somebody who has, for example, according to this definition, if a medical mistake leads somebody to come out of surgery a C5 quadriplegic. This redefinition, Senator, of mental or emotional pain raises that bar to one that acts as a redefinition to make it a cap. So you have to, if somebody who overcomes a horrific injury and returns to their daily routine, because we honor victims who try to get better, by achieving that under this definition, they cannot make a claim for mental anguish because they haven't suffered a disruption to their daily routine. That is not current law. And then you have to have mental anguish arise because they're trying to conflate, they're trying to collapse these elements of damages. It has to arise out of loss of consortium, which is the loving relationship between a husband and wife or a parent and a child, loss of companionship in society, which is really a wrongful death damage, or the loss of enjoyment of life. So they're pigeonholing the idea of the mental suffering of somebody who's a sexual assault survivor or somebody who has left an impairment where they'll never be able to walk again, and say if you don't have these characteristics of mental anguish, you have no compensable mental anguish. This is unprecedented. We can live under current common law, and we can talk about these other things, but this acts as a limitation on what is not just the standard of law, but makes it where identifiable classes of people who suffer mental anguish have no recovery.
Thank you again. Did you have something to add?
I'd like to speak to that just a little bit. Causes a substantial disruption in a person's daily routine straight out of Texas Supreme Court opinions. So you've just been told that it doesn't exist. In fact, it's straight out of Texas Supreme Court opinions. We'll be happy to send you the citations for that. If the disjunctive part of this, the definition, it says arises from loss of consortium, loss of companionship in society, loss of enjoyment of life, or other similar mental or emotional injury. So it leaves open, it's a list, and it says, or other things. So you can put in other kinds of mental or emotional loss. It's not a limitation, but if that conjunctive and something about that definition needs some tweaking, I was at the trial lawyers building, as Jack said last week, to say, are there things about this bill that need some tweaking? Are there some things you guys are discomforted by? And I didn't get a response to that at the time. But if that's something about that conjunctive in here needs some work, then I bet Senator Schwertner would be willing to entertain that work. But it is not a bar. I just disagree with Jim Perdue. It is not a bar on a person's ability to recover. They would plead for mental anguish damages. They would go to the jury. They would submit their evidence for mental anguish damages, and they would get an award for that. And the jury would be given a definition that it can then use to determine whether this person has mental anguish. But it has been in the law for a substantial disruption of their daily routine for a long time.
Well, thank you, Mr. Parsley, and you opened the door for one of my favorite questions, which is how would you improve this bill?
How would I improve this bill?
Yes.
Well,
You said it needed tweaking, so how would you tweak it?
Well, Jack Walker is correct that the database it refers to right now is not yet functional. The legislature is considering funding that database so that it will be functional. In the meantime, it needs to have a standard that fills in the gap between now and when that database becomes functional, and it needs to be based on actual market forces and not on just numbers that someone comes up with and writes down. So that needs to be improved about the bill, and we've talked to Senator Schwertner about that. That's the major thing I think would change. And then beyond that, I think that it's a good faith effort to try to move the pendulum away from where we are today, which is a litigation environment that's discouraging something like Mr. Balderas' company from investing capital in Texas, and moves the pendulum back toward the middle some. And I think it's a very good effort at that. And so we at TLR are happy to be participants in a process to make it better if there's conversations that need to be had. As I said, I tried that last week.
Thank you. Mr. Walker, other than strike everything below the enacting clause, how would you improve the bill?
Well, I would like to clear up when we had our meeting, I asked Mr. Parsley that same question. I said, what would you be willing to change in the bill? And he said nothing. I'd like for every word in this bill to pass. So that was the extent of our meeting. I think if there's something to be worked on in this bill, it's the medical damages part. It's coming up with a standard or something that can be anchored. I don't think it's anchored at workers 100% or workers' comp. I don't think it's anchored by a database that I don't think was set up to do it and is probably years away from doing it, but there's probably somewhere that can be done so that this problem, this issue can be addressed. I would dovetail with what Mr. Perdue said. The rest of the bill, there are two separate issues that you're addressing here. In the first part of the bill, the medical damages is more rank and file type cases, okay, that they deal with this and deal with on a daily basis, and there are folks that abuse the system and can be fixed. The rest of it goes to catastrophic cases. And has nothing, they don't have anything to really do with one another, all right? But the second part of the bill is a total rewrite of the civil justice system, and it completely devastates catastrophically injured individuals, which I think you'll hear about today, that would have no recourse under the definitions and the restyling of the non-economic damages. And then again, I disagree with regard to the cap. I think it's completely unconstitutional. And so there is no way to truly rewrite that when the way this legislation was written. It takes the decision of the jury, who are the sole deciders of the facts, and allows a judge to go back in and make it insert his own judgment into it, and that's just completely unconstitutional.
Well, can I speak to that just
Certainly.
for a second? This bill is built around a concept called remittiture. I went and looked. The first references to remittiture in Texas statutes in the civil justice system was in the codification of 1856. It mentions remittiture. It is a process that exists in Texas and it exists across courts across the United States, including the federal court system, where a judge, having heard the same evidence as the jury, can say at the end of the trial, if the jury's returned its verdict, the number seems manifestly too large to me, and it needs to be lowered. That's called remittiture. It is a judge looking at the evidence over the jury's shoulder and having a different view of it. And it has existed in Texas since 1856. So Connecticut does exactly what this bill does. Connecticut says in its statutes, if a verdict is over $1 million for non-economic damages, the judge shall consider remittiture if it's manifestly unjust. So it is not even new to us, this idea. And it is not unconstitutional, anything we've done since 1856.
May I respond? This use of the term remediator is not using the term as it is meant. It bastardizes the term of remediator, because remediator is something that does exist in common law, and so does something called additor. Remediator and additor exist in law, and they allow a judge to look at a jury verdict and go, you know what? You asked for $3,000 in medical bills, and they gave you $45,000. Okay, there's no evidence to support that. So if you take this up, you're going to get reversed. So here's what I'll do for you. You can accept the $3,000 you argued for, or I'll give you a new trial. But the judge cannot come in and say it's going to be $3,000, because that's the sole province of the jury. So any invasion where the judge comes in and says, I'm going to put my judgment in for the jury is unconstitutional, because the Texas Constitution guarantees a right to trial by jury and guarantees that the juries are the sole finders of the fact. So that's not how remediator is. The only thing that remediator and additor is, the judge has the hammer of a new trial and can say, if you don't do this, I'm granting a new trial, you're doing it again. But they do not come in and rewrite it. That is not what a remediator is.
How would the provisions in this bill regarding non-economic damages impact damages for, say, a brain injury or another lifelong debilitating illness?
So I'm going to let Jim, that's kind of Jim's territory. You want to handle that again?
I will. So in the conflation, Dean, of the way they define non-economic damages, because they've eradicated the area of physical impairment and conflated, then they've just essentially combined loss of function, comfort, and society with mental anguish. The Texas Supreme Court has recognized that those are separate elements. So if you have a brain-damaged child who suffers an hypoxic injury at birth and is left for a life of daily care and impaired, that child's anguish is one aspect of the damages as it exists, but the impairment to the child's function has always been something that the common law has recognized is a non-economic damage. It should be compensated if there was culpability, because you have taken a value of human life that we recognize in law. And the Texas Supreme Court has recognized that those are separate. Texas Supreme Court has said that pain and anguish is separate from physical impairment, is separate from loss of comfort in society when you bury a loved one. This bill says that's no longer true. This bill says that mental anguish is all of those things, and physical pain is limited to these things and nothing else. And so it changes fundamentally the non-economic damages for a brain-damaged person.
So is there any provision or any allowance for a lifetime of care or inflation over a lifetime of care as a result of an injury?
Well, so now you're talking about future economic damages, that is the medical expenses necessary to take care of a brain-injured person, right?
That's in Section 4, right?
There's a section on that, and of course, one of the oddities is this bill mandates that future medical care now gets turned into the reimbursement rate on insurance that is presumed to exist for the rest of the lifetime of that beneficiary for what it would have paid the year before the injury happened. So if you have a 2-year-old child who is left an invalid and brain damage for the rest of their life, for 70 years, the future medical expenses is essentially calculated as the health insurance reimbursement for whatever that necessary medical care is as of the year before the injury happened for the next 70 years, assuming that child has maintained equitability to insurance and is not left on the Medicaid rolls of the state because of poverty.
Thank you so much.
Well, future damages are a unique challenge in themselves, future medical damages, because it could go a year into the future, it could go 50 years into the future or longer. And so how do you figure out what that number is? And you have to figure out what the healthcare pieces are for the period of time and what that amount of money would be to pay for those, and then you factor in some inflation, and then you have to discount it back to where you started in a sense. So what this bill says is you look at that lifetime of care and you price everything based on what today's amount is times 150%, but you award them for their whatever care there is for their entire amount of time. This bill doesn't change that fact. What it doesn't allow is for the numbers to be unconnected to anything. It connects the numbers to 150% of amounts actually paid. So again, it's an attempt to, in a good attempt, it's the right way to do it, to connect the numbers for future medical to something that's in the market today, so that it's not just a number that the witness made up because that's the best they could do. So it's an attempt to connect to the market, and I think you have to, in fairness, for everybody involved in the litigation, have some market-based element even to future medical damages.
Thank you so much. An analysis that I read about this bill says that it does not cap any damages and it does not set medical billing rates. Do you agree with that?
That's absolutely true, and let me answer those. First of all, we've talked about the cap on damages. It's not a cap. It's a process called remediature, and the trial judge, if the trial judge says, I'm not going to order remediature, then the trial judge must write down why he or she believes the number is the correct number. And so it's either you order remediature or you give an explanation. So that's not a cap, and as I said, Connecticut's doing it today. Hard caps exist all over the United States, and hard caps exist in Texas in medical liability cases, for example. We have caps that are just it. This is it. This is the number. That's all you get for non-economic damages, and they're all over the United States. But this is an attempt to go in the middle. You've got a problem here I believe you'll hear about today, and you could do hard caps. You could just say, here are your caps on non-economic damages. You could say, we're going to do nothing about the problem, or you can try this process about remediature where it's somewhere in the middle. And that's what it is this bill attempts to do, is to try to find some middle ground between hard caps and nothing. And then on caps on medical damages, it allows a doctor the opportunity to say, I'm going to submit an affidavit at 150% of the all payers claims database, and then I'm done with this lawsuit. I don't have to be a witness at this lawsuit. I just can walk away and go back to my medical practice. But the doctor does not have to do that. And the doctor can come to trial and testify to any amount he or she wants as reasonable and necessary medical expenses. This bill does not limit their testimony. So therefore, I do not believe it sets medical billing at all. What it does say is at the end of the day, the judge must apply this 150% number to whatever the damages submitted by the doctor are and believed by the jury.
Thank you, Mr. Walker. Mr. Perdue, do you agree that this bill does not cap any damages and does not set medical billing rates?
Well, it does both.
It does both?
Yes, it caps damages for the reasons that I testified before, because the jury is the sole renderer of the verdict, and this bill allows a judge to go in behind the jury and actually lower the verdict, and that's unconstitutional, and that is a cap. Okay. The second part is it does cap medical damages, because what Mr. Parsley just said is that a doctor can come in to testify as to any number that they want. That's not true, because under this bill, if the submitted medical bill is not within 150% of the amount set by the database, then it's not admissible in trial. So that's not true. Now, as we've talked about, the medical damages issue is something we can discuss, but the damage cap at the end of this bill is absolutely a cap, and it is also unconstitutional. I'll just leave it at that.
Well, it actually, what Jack said is actually, it's not. I didn't say it was a cap on medical damages. It is a cap on the medical damages. Your question was, does it set medical billing rates? And I said it does not set medical billing rates, and those are two different things.
My question was, does it cap any damages, or does it set medical billing rates?
Right, and I said it does not cap non-economic damages, and it does not set medical billing rates, and that's correct. And what I told you about it is I think equally correct. That the doctor is not prohibited from testifying to any amount of money. It is not a cap on testimony. It's not a limitation on testimony. So Jack is just not right about that. It is a cap on the damages that the judge applies at the end of the day. It's not a limitation on the doctor's testimony. The doctor can testify to any amount, But after the jury returns its verdict, then this bill is set up then they apply this 150% to what the jury returned its verdict for.
Thank you so much. On page 17 of the bill, there is a provision for claimant disclosure requirements, section 41.105. And basically, it's a mandatory provision for an injured person to provide disclosure as to who referred him or her to a provider of health services, including the name of an attorney, to include name, address, and telephone number, and if the person making the referral was the injured individual's attorney. And then there's a reference to an anonymous list of persons referred by the attorney to the provider in the preceding 2 years. Would any of you like to comment on that provision and why it is needed and the impact of that provision?
I commented on the layout of the bill.
Pardon?
I had commented on this when I laid out what I was talking about, because what this requires is there is probably I don't have as much problem with some of the disclosures in this case. This one is awful broad because it goes beyond just providing the information. If you had referred your client to the doctor, it now requires that I keep a list as a lawyer, and then I also keep a list of the amount of money that I paid to that doctor, and that is not relevant to anything in the case. But the problem that it has is under the next section, that automatically comes into evidence. This irrelevant evidence about how much money I might have paid on behalf of some other claimant, under some other case, under some other different facts, having nothing to do with this case, that comes in. You're going to create a couple of things. You're going to create litigation within litigation, because then you're going to be fighting over, if that comes into evidence, then the plaintiff's going to have to explain what that is. You're going to spend extra time at trial having to deal with the fact that irrelevant evidence has been automatically admitted into evidence. So that's the problem and the issue that you have with the broadness of these disclosure requirements, in addition to everything else that's required to be disclosed. Each one of those elements is a problem.
Thank you so much. Thank you to the panel. Thank you, Mr. Chairman.
Thank you, Dean. Senator Schwartner, you're recognized.
Thank you. I know we need to wrap this up to go to the floor, but and I appreciate the discussion on everyone's part and the questions asked by Dean Zaffirini. Regarding remitter, Mr. Walker, you mentioned a remitter scheme, I think, in your opening comments, and I just want to make sure that the members of the committee understand that the concept of remitter is well-founded in federal and state law. The first, I'll refer y'all to a Southwestern Law Journal 1960 article about Texas remitter practice. The federal courts have used it since 1822. Virginia used it even before that. The Texas has been around since 1846 here in Texas, and when the appellate courts came in 1891, it was a well-grounded initial concept of the appellate courts. So it is a mechanism for judgments regarding awards to be diminished and sit back down to the jury to reevaluate that. There's other ones in which actually the trial judge can essentially be concerned about the entire verdict, a judgment notwithstanding the verdict. JNOV, I think, is the term of it, and that they basically kind of throw out and disregard the jury's verdict entirely and replace it with their own judgment. So there's aspects, so I'm not an attorney. Y'all are much more learned than I am, and I'm sure y'all have counter arguments to what I've said, but there's the Texas chapter, what is it, Rule 315 regarding remitter. So this is not a novel, made-up concept that is being advanced here, the diet on this chamber today. It is something that certainly has its place in law and place in civil actions, and we are trying to find a fairness here between those injured and aggrieved and those, obviously, that are in the defendant stance. So with that, I assume we need to break, Mr. Chairman, and we have a lot more testimony, and again, I look forward to working on the issues brought forth regarding records particular to the case, conjunctive, the medical damages section. I'm open to discussions regarding finding the best way forward here with Senate Bill 30. Thank you, Mr. Chairman.
Thank you, Senator.
Thank you.
Thank you.
I thank each witness for your testimony and members for your questions. And so I know a lot of folks are here to testify on the bill. We have some more invited and some public testimony for and against the bill. We will have to stand in recess in a moment so that these tables can be removed and the Senate can come in. So I'll be making an announcement, but it's our intent to come back here in the chamber 30 minutes after adjournment or final recess of the Senate today. And so with that, Senate Committee on State Affairs stands in recess until 30 minutes after adjournment or final recess today here in the chamber. Good afternoon.